God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice Paul Hart-Smith. To my left, your right is Justice Chauncey Wood. We'll be your panel for all 6 cases this morning. I should say that we do expect to take a break after our 3rd case, and we appreciate everyone being here on time, but particularly those of you who have cases in the second half of the morning. If you want to go out in the hall, go in the room off to the side where you can listen to arguments, but work, do whatever you want. Feel free. You don't need to stay in front of us. We're not going to call any cases out of order. So just don't want you to be sitting here doing nothing if that's not what you want to do. If you've been to the appeals court before, you know that each side gets 15 minutes. There's no rebuttal. We have read your briefs. We've read the record. We understand the factual and procedural background. We know what your arguments are, so I would just urge each of you to get right to your key points. With that, I will call the first case, which is 25P20, Commonwealth versus Zachary Harris. Mr. Oskern.
Thank you. Good morning. May it please the court, Barry Oskern on behalf of Mr. Harris. I'm going to jump right to the key point, and that is the notion that the seriousness of the argument in and of itself was sufficient to put Mr. Harris on notice that he was going to be facing criminal charges. There are cases that seemingly support that notion, but every case involved either a driver striking a pedestrian, driving or hitting a bicyclist, where it was clear that the driver knew that they had done something bad. And in addition, those cases tend to involve, when you look at the actions that the defendant took, oftentimes they flee the scene. You know, they're found hiding behind a house, or they very quickly retain an attorney. It's clear from our case law that those cases involve a defendant who was highly aware of the wrongfulness of what they had done.
Well, Attorney Oskern, what should we make of your client's, for lack of a better term, admission that he was at fault? You know, he was looking for a bagel or his phone, and I think most people would think if they caused that sort of pileup, then there may be repercussions that land on their doorstep, no?
So the interesting thing is Mr. Harris was very forthcoming about what happened, took responsibility immediately. The other cases all involve people who were really trying to evade the detection by running away. So that's one distinction.
The point is he knew.
He
knew that there'd been an accident.
He knew that there had been an accident, but I would say
3 vehicles.
This was a bad accident.
He was at fault, right?
Okay. He may have known that there could be repercussions down the road. You know, perhaps someone was going to sue him. But that's very different from knowing that criminal charges are going to be forthcoming.
The purpose of notice is so that someone won't be surprised by filing criminal charges down the road at a time when they might have lost evidence or not retained evidence or forgotten something or found it difficult to track down witnesses. Is that a problem here?
Well, I guess my answer would be, I'm not sure that he was necessarily, I'm not sure he could have come up with a defense, you know, had he been given a citation initially, but was he prejudiced by the way that this played out? I think our case law says, you know, we don't look to see that the defendant was prejudiced. We look to see that the law was followed.
Right, but we also, before we get to that point, we look to see whether the purposes of the law were frustrated under the 3rd exception. And one of those purposes is notice. So how was the notice purpose frustrated here by the delay?
One of the concerns underlying the statute is the possibility of manipulation. The tickets could be fixed. All we know in this case is that the chief waited for a week before issuing his citation. We don't know, you know,
What could have happened in that time?
We don't know what could
the DA
have...
said, who could have gotten to who, that
Well, and
sort
this
of thing.
case is a little bit unusual because we know that a senior prosecutor came to the scene, at some point made a determination that charges were not to be issued.
Is that usually the DA's call?
It's my understanding as a matter of practice that anytime there's a serious accident and there's a chance that it could involve a fatality, that a senior prosecutor is called.
The DA is called to come to the scene, or an NADA. But who is it that files an application for a complaint
It
usually?
would be the police department.
Right. So,
Can I drill down on that? So first of all, the facts. I think I understand that this senior prosecutor goes and he makes an assessment, and his assessment is, I don't think charges are warranted. He tells State Trooper O'Connell. I think it's, then the next question is to me, did the chief of the
Chief
Gill,
Redmond.
of the Gill Police Department know about that assessment?
I believe he does because
And do you have a record citation for that?
I would have to go back and look at the transcript of the first hearing, because I believe one of the questions I asked the chief, involved the prosecutor.
Right. But sliding past that, there's two purposes. Notice, it sounds like you're conceding that given the seriousness of this, there is no real argument about notice to answer. Or you, well, all right, then I don't want to put words in your mouth. But focusing on the first purpose, the possibility of manipulation and misuse, if the chief knows that somebody else, a prosecutor, has opined that there shouldn't be charges here, and a week goes by, how does that inform this analysis of the opportunity for misuse?
The short answer is I don't know, because I don't know what the chief's thought process was. It's also unclear as to who the prosecutor spoke to directly. And nobody could really remember. Everybody remembers that the ADA came on the scene, that the ADA made a determination at some point, but people were very fuzzy about when that actually got communicated. But I do want to go back, Justice Wood, to the idea, are we conceding notice? We're not, and here's why. Because all those cases that sort of talk about the severity of the accident, implicit in them is that the driver was highly aware that people were severely injured. We have no evidence in this case that Mr. Harris was aware of the nature of the injuries. We know that everybody went to the hospital.
well, but he may not have known about injuries, but he knew that 2 other vehicles were involved.
Yes.
And when the trooper said to him in the hospital they were significantly damaged, he said, I would imagine so.
He said, I would imagine so. And again, I don't want to parse his words, but he did not say, yes, I saw that. He said, I mean, obviously he'd been through a bad accident. He knew he collided with
So
one
at
car.
least as of the time he's in the hospital, he's been told that the 2 other vehicles were seriously damaged, and he doesn't act surprised. Instead, he says, yeah, I would imagine so.
Correct. But
So he's on notice in that regard.
he's
as to
on
the
notice of damage to cars. That we concede. But if you go back and you look at all the lead cases that talk about this notice, this idea of implied notice, and I'm referring to Kenny, Babb, Pappas, they will involve serious injury to people. Oftentimes, where people either died or were at risk of dying. I believe it was a Commonwealth's burden to show that Mr. Harris was on notice, that he knew that other people were in fact injured, and there was nothing in the record to support that. The other piece of it is...
I want to ask, and maybe this has to do more with the no-fix purpose of the statute. O'Leary, which is not a very old case, recognizes that an accident that's serious enough to create what the court calls an ineradicable record of the event ensures that the anti-abuse purpose of the statute is satisfied. So here, this is not a one-car accident. This is not a rollover where maybe the passenger got injured, as in one of the other cases that we've had recently. I mean, this is a case where you had at least 5 law enforcement agencies responding. You had 3 vehicles involved. You had somebody was eventually life-flighted, not directly from the scene, but from one hospital, I think to a hospital in Boston. So, I mean, this is not a case that could be swept under the rug easily because there are many agencies that have records of this accident occurring. Why isn't that enough to satisfy the no fixed purpose?
So the severity of the accident is one factor, but the courts also look at other things like what was the length of delay in issuing a citation. I think in Pappas it was 4.5 hours. Here we're talking about a week where the chief did nothing. And the other piece is oftentimes, even though the citation was not filled out and delivered the way the statute called for, but law enforcement will actually put the individual on verbal notice that, hey, charges are forthcoming. If you'll recall, there were 2 evidentiary hearings.
Yeah, and we know that the Commonwealth conceded that the defendant was not directly informed that charges would be forthcoming.
And
despite the judge's finding.
I questioned Trooper Pottinger quite closely by saying, did you ever tell him, you're looking at criminal charges, you could be going to court down the road? Answer, no. So to my mind...
Yes, those cases involved somewhat different circumstances, but how were the purposes of the statute frustrated here? Either one.
I think there is a concern in general, and I'm not saying that it was necessarily implicated in Mr. Harris's case, but when the chief waits a week to decide what to do, that allows for the possibility of manipulation during that period where we don't know what's going on.
I agree with you that if we were writing on a blank slate, the passage of time, and no one can really know what's going on behind the scenes. The passage of time creates opportunities for manipulation without casting any aspersions on the chief in this particular case. But the SJC has said an accident that's serious enough to create an ineradicable record of the event ensures that the anti-abuse purpose of the statute is satisfied. So we don't really look in general at whether there was a gap in time where something could have happened. It seems like we're supposed to look at whether there was an ineradicable record created at the time. And if so, then we don't really worry about abuse because no one can pretend that this accident didn't happen at that point.
I think my answer to that is if you go back to the case, not only was there serious bodily injury, but there was also evidence presented to the court that the defendant was aware of it. So to my mind, just sort of looking at that term, ineradicable record, all those cases contain evidence where the driver knew exactly what had happened. So I think there needs to be a showing of awareness. And the Commonwealth did not produce evidence during the evidentiary hearings that Mr. Harris was aware. And here's maybe a way, Justice Sachs, I can answer your question. Let's say that there was a really bad accident, terrible accident where people were, severely injured. I mean, in this case, it turned out by that afternoon, everybody knew the accident wasn't quite as serious as people had thought. But let's say we had a worse accident, and you looked at the photos and you'd say, yeah, here's the ineradicable record. What if the driver had hit his head on the steering wheel and was unconscious, awoke in the hospital, was visited by the police, just like Mr. Harris was, and he says, I don't recall what happened. Now, the accident is just as bad. The quote-unquote ineradicable record of the accident, the crime scene photos, the skid marks, those still exist. But would anybody suggest that that driver was placed on notice of what had happened and that criminal charges would be forthcoming if they had no awareness? Obviously, the answer is no.
Well, the ineradicable record point goes to the frustration of the no fix purpose. You're back to notice now. He might not remember what happened if he had hit his head and woken up in the hospital, but I mean, that might be a different case. So then, at that point, he wouldn't know that he had to preserve evidence or go chasing after witnesses to make sure. But here, he did know. You know, he recognized that he had caused the accident, essentially through his own negligence, and he recognized that there was serious damage to at least two other vehicles.
We're talking about Mr. Harris, right? But I guess to my mind, if you're Mr. Harris lying in bed, the police come to you, they ask you, I think the interview lasted about 10 or 15 minutes, what happened, walk us through it. Again, he admits what happens. And then the police leave the room without ever once mentioning the possibility of court proceedings. I mean, again, this is going back to notice. I think Mr. Harris would reasonably assume, okay, you know, maybe somebody will sue me down the road, but I'm certainly not looking at court until that citation showed up late. Part of the problem with our cases is, to my mind, every case seems to rise and fall on its own nuances, be it the seriousness of the accident and the injuries, the awareness of the driver, the delay. But at the end of the day, and I see that my time has just expired, I'll simply end by saying I've yet to read the case that says that a severe accident involving vehicles that the driver knew of, that's enough. And I would rest on my brief unless there are more questions.
No,
and I'm amazed at how 15 minutes goes by so quickly.
Yes. Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court, Assistant District Attorney Bethany Lynch, representing the Commonwealth. As a sort of a housekeeping matter, I'd like to address Justice Wood's question about when the ADA was on the scene and when he told Trooper O'Connell. On page 64 of the first transcript, Trooper O'Connell testified that on a later date, the ADA concluded criminal charges would not result. He didn't know when, but it was not that day, spoke to him within a week possibly. So even Trooper O'Connell and the ADA, that decision was made, but there's no evidence that it was made on that day. Or that it was, and then on page 65, Trooper O'Connell says that he can't remember if he found out directly from the ADA or if he found out from other troopers or who told the police chief. So this was an investigation that began with this huge accident. The police chief responded to the accident because it was within his jurisdiction. Seeing the seriousness of the accident, he immediately called in the state police. And the state police took over.
Why,
yes,
I think, know those facts. Mm-hmm. Why did he wait a week?
He waited a week because he was waiting for the troopers who were doing the investigation directly, who were speaking to witnesses, who were looking at the police, looking at the vehicles, who were checking with the victims to check on their medical conditions. They waited until those troopers assured him that there was no chance of more serious injury or death to follow.
But, okay, so that
And as soon as he found that out, he sent the citation that very day.
Right, that doesn't make sense to me. So first, I'm trying to be transparent. First, Pottinger, Trooper Pottinger,
yes.
Interviews the two most seriously injured people.
Yes.
The pregnant woman and Rosner.
Yes, Rosner was the one who was hit directly head-on and was airlifted.
Right, and he actually went into there, or at least talked to the husband of the pregnant woman and to Rosner herself on the day of the accident, and determined at that time there was no likelihood of fatality.
At that point, that is what the husband believed.
And
but
that was also what Pottinger believed, and Pottinger relayed that to the chief of the Gill Police Department on the same day as the accident happened.
I don't believe that is true. I believe that the investigation occurred and that perhaps Pottinger knew that, although I believe what Pottinger heard from the husband was that at this point the fetus seemed okay, but they were still going to do many follow-ups because it was a high-risk pregnancy to begin with. So I don't think that it's an absolute that on the day of the accident the troopers knew no one was going to die. Well, these people, okay. I mean, they were airlifted. They not that the trooper didn't speak to people and didn't get initial information, but as an investigating officer, he testifies that he has seen fatalities or more serious injuries occur later.
Even if there's still a risk of fatality, how does that justify delay where a charge that results in a fatality is not subject to the no-fix law.
Well, I think he was looking for fatalities or the level of seriousness of the injury. He wanted to make sure that the injuries were non-life-threatening and the investigation was complete.
Does it make a difference? How does it make a difference if the injury is non-life-threatening to the charges that he could bring absent to death? I mean, it's still the same negligent operation and, Mark Lane departure.
It is. And I would just say that they were
Those depend
taking
on how serious the injuries are.
Well, I think they were taking a more cautious approach rather than initially giving out a citation.
Is that a more cautious approach? Wouldn't the more cautious approach be to issue the citation right away?
It could be, but I think that we shouldn't expect these officers to just jump the gun when they didn't have all of the information and hadn't completed their investigation at that point. They knew that
I don't understand the jumping the gun argument. I mean, I understand that in some cases it's evolving and you don't want to jump the gun. But here, there's a no-fix statute which says file charges promptly, the day of. And accepting, for the purposes of this argument, my recollection of the record, that Pottinger told the chief there are no life-threatening injuries here. And within the next week, he came back to the chief and simply said, right, I'm confirming nobody died. Assume for the sake of argument that that's what the record supports for the purposes of this argument. How does the chief's how is the chief jumping the gun if in that context he issues a citation after Pottinger tells him nobody's going to die?
Under those facts,
Yeah.
I would suggest that it would not be jumping the gun.
Okay.
That if the chief knew for a fact that the state police investigation had completed and they had assessed that there was no life-threatening injury and these were the charges that were to be filed and that they had given it back to the Gill Police, because the Gill Police chief was under the impression that the Mass State Police and the CARS Accident Reconstruction were investigating this accident, and he was apart from the investigation at that point. If he knew for a fact that that was it, the investigation was done, there was no more facts to be collected, and this was the charge that was to be issued, if that happened that first day, then that's the day that the citation should have been issued.
Right. But the only thing that's crucial that could change to Justice Sachs's question point, the only thing that could change what he could write as a citation is if somebody dies. The seriousness of the accident, the forensic reevaluation to figure out how the crash happened, that's all irrelevant. And the fact that somebody gets a really worse injury is irrelevant legally. The only thing that he needs to know from this state police investigation is somebody going to die? That's the only thing that changes his charging decision, right?
I believe that's true, yes.
Okay.
But not knowing that on day one, I think that because in the police chief's estimation, the investigation was ongoing, the state police did not give him all of the information until the week had passed. At that point, they were checking in with the victims, they were checking in on everyone's medical conditions, and after a week, it became clear that there was going to be no fatality was going to result. And so at that point, the state police affirmatively notified the Gill Police Chief that we're done with our investigation.
A citation requires probable cause, right?
I'm sorry, I didn't.
Issuing a citation requires probable cause?
Yes.
Doesn't require proof beyond a reasonable doubt?
It does not.
Okay, so was there probable cause to issue the citation on the day of the accident?
I mean, there was for the charges that ultimately he was charged with. I think that the issue is...
Certainly no probable cause for motor vehicle homicide.
Not at that point, no.
Right.
But I think that...
Can the chief wait until there's proof beyond a reasonable doubt of the driver's guilt of some motor vehicle offense before filing the citation? I mean, yes, the investigation should always proceed until there's... till people really know what happened. But
Right.
the statute says when you know the facts that are sufficient to issue the citation, that's when you issue the citation.
Well, I mean, the statute says that if you know the facts and there's no need for further investigation, there are exceptions to the statute, including the fact that the investigation was ongoing here.
Well, that's not really
And
literally an exception. The exception is where additional time was reasonably necessary to determine the nature of the violation or the identity of the violator. But this doesn't apply in the case of a death.
Right. And so in
Merely the
that-
fact that an investigation is continuing to dot some i's and cross some t's isn't enough.
Well, I would suggest this wasn't just dotting i's and crossing t's. This was the police chief had a very brief conversation with the defendant. Everybody was out of the car. It was chaotic scene. All kinds of things were going on. The entire Route 2 was blocked. And at that point, the state police came and they took over. And the state police then spoke and they determined what happened during the scene, whether it was negligent operation, that he was reaching for his bagel, his admission to what he was doing. That wasn't the police chief that found out that information. That was the Mass State Police in speaking to him.
Pottinger. And when did when did Pottinger tell the chief that?
I don't think we know exactly when he told the police chief that, because it was ongoing. They were looking at the car, they were looking at these things to make, I mean, yes, you look at this and it's a head-on collision, and so you could say, well, I think probably he crossed the center line, so he's obviously at fault, and so we're going to charge him, or we're going to issue a citation. But rather than do that, they wanted to look at all of the situation. They wanted to look at the entire situation. They wanted to look at the cars. They wanted to assess the skid marks. They wanted to speak to the various people. All of that was done, but it was not done by the police chief. And he was in contact with the Mass State Police and the CARS unit in that week's time. He was checking in with them, and they were reporting as their investigation was continuing. And I believe that's what the record shows, is that they were checking in. And once the state police said, okay, there's not going to be a fatality, these are the charges, then the chief issued it immediately. And I don't think that...
Couldn't the trooper have issued a citation?
I'm sorry?
Couldn't the trooper have issued a citation? The trooper Pottinger, I guess, who interviewed the defendant in the hospital?
I suppose he could have. I'm not sure exactly if they're
State road, right?
jurisdictional. It is a state road. But if it wasn't going to be a state police case that they were pursuing, then they left it back to the...
That's a matter of arrangements
Right.
between the state
Right.
police and the Gill police.
And so once the
But
state police...
does that sort of informal understanding trump the statute?
I don't think it trumps the statute, but the statute and the exceptions to the statute, I would suggest, are based on reasonableness. And I don't think that there's a lack of reasonableness here, that the state police, having taken over the investigation and done vastly more investigating in these situations and in this particular case than the Gill police chief, having taken over the investigation, they completed it. The state police concluded that they were not going to pursue charges, and at this point, there are no further injuries that we anticipate and everything. And that was when they definitively notified the police chief that this is it. There's not going to be anything further from this. There's no, recklessness. There's no other crime that we're looking at. And so then that day, the day that the Gill police chief was told that by the Mass State Police, he put that citation in the mail.
It seems to me that, there's another way to look at this. So we have some evidence that an ADA comes to the scene, assesses it, and says, yeah, no charges. We're not sure when, but that's his opinion. Then we have the state police CARS unit and another person from the state police, 2 units, I guess. They do their assessment, and they conclude that no charges should be brought. And then, after all of that, a week later, the chief of Gill assesses all this and comes to a completely different assessment. It seems to me, not to cast aspersions on why he did that, and to be clear, we have no evidence they did anything nefarious, but it's inconsistent with the other 2 analyses. And isn't that consistent with the concern of the no-fix statute that delay creates the opportunity for misuse?
Well, I don't think it is inconsistent. I think at various points in time, other agencies and the ADA looked at the evidence, and that's what they came up with. They decided that there wouldn't be, I wouldn't say that there wouldn't be more serious charges. Like there wouldn't be more than a citation. There wouldn't be, so the ADA looked at it, and I don't know that, I guess he concluded no criminal charges to result. So once they made those determinations, there's no indication that the Gill police chief knew along the way that they had made these determinations. It wasn't until Pottinger reported back to him on the 7th day and said, nobody's going to die, there's not going to be a major motor vehicle homicide, there's not going to be anything like this. The only whatever you're going to do, you can do now. And I would suggest that that was reasonable. There was no nefariousness. There was no indication of sloth on the part of the police chief. He wasn't just twiddling his thumbs. It wasn't like O'Leary where they just waited 9 days for no reason because it's on some policy book. He was waiting to hear the results of the investigation by troopers and apparently by the ADA too, mixing that in as well, about what their assessment of what the investigation showed. And as soon as he had that information, he then issued the citation.
Can I ask you a question about the wording of exception 3, which is where the court finds that a circumstance not inconsistent with the purpose of the section justifies the delay. I'm paraphrasing that last part, but it says the court finds that a circumstance. So what is the circumstance here? Even if we accept your view that the neither of the purposes of the statute was frustrated, still, what is the particular circumstance?
I think that the circumstances, that you need to look at the entire accident scene. And the fact that this was a multi-car accident, it was a chaotic scene, a lot was going on, different agencies were investigating, and the agency that ultimately issued the citation, who technically it was their jurisdiction on that section of the highway, they were not involved in the investigation of this huge accident.
Well, you know, the chief might have, and he was no doubt very busy that day, coordinating what was going on with the different agencies, but why not the next day?
Well, I believe there was evidence that they were checking in periodically, but it wasn't until that 7th day that he knew for sure that the state police weren't going to take the case, that it was going to be a citation case versus anything different. So he was waiting for them, and they were actively involved. They were investigating, they were checking in, they were looking at the circumstances.
So, in as few words as you can, what was the circumstance?
The circumstance is that in the case...
It wouldn't apply in every accident.
In a case with a severe accident that resulted in severe injury with multi-agency involvement in the investigation, a reasonable delay does not frustrate the statute. I guess that's the best I can do in terms of trying to put it into a sentence.
Nicely done on the fly.
If the court has no further questions, I would rest on my brief.
Right.
Thank you very much.
Thank you very much. Thank you both for a great argument. All right, our next case is number 24P448, Commonwealth versus Figueroa.
Good morning, Your Honors. May it please the Court, my name is Matthew Coase, and I represent the defendant, Israel Rosa Figueroa. In this case, there was a voluminous, the jury was exposed to a voluminous amount of highly inflammatory bad act evidence regarding the sexual abuse of Mr. Rosa's granddaughter and daughter, who were not the subject of this particular trial, or the victims subject to this trial. Both the nature and the volume of this bad act evidence, combined with the prosecutor's opening statement and closing arguments, overwhelmed the case and distracted the jury from its core mission of evaluating AV's and DVR's claims.
So I just to jump right in. One thing that surprised me when I read the Commonwealth's brief, and I hadn't understood it in your brief, was that these cases had been joined. So there was about to be a trial involving, the Commonwealth moved to join. I think you or trial counsel, I can't remember if you were trial counsel, opposed that, and the trial court granted the motion to join. So there was going to be a trial involving all 4 of these alleged victims. And then at the last minute, the Commonwealth wanted to do some forensic testing, and so it was requested that they be severed, and that's what happened. But so just a week before, the 3rd and 4th alleged victims would have been testifying about charges, and a week later, they are prior bad act witnesses, and we have this issue. Have I got that procedurally correct?
Yeah, that's my understanding,
Okay.
Yes, Your Honor.
Okay. Does that inform us? I mean, to me, it somehow does, that these people who were just about to be, I guess appropriately, if the joinder, do you have any comment about the joinder, the merits of the joinder? And is that relevant? Really what I should ask is that legally relevant, that joinder?
I don't think it's really legally relevant. I think from my perspective, once the case has been severed, then the case has been severed, and then the case moves forward in that fashion. And I think, Justice Wood, you bring up a good point in terms of the procedure here, because when the case does get severed, it's because the Commonwealth wants to do more testing. And I do want to talk about the testing, because I think that's the hair is an important issue in this case. But the trial court judge does kind of suggest to the Commonwealth, well, you can always bring a motion for prior bad acts. And, certainly it was within the Commonwealth's right to do so, but it kind of follows the court's advice, and it brings the motion for prior bad acts. I do think that the timing is interesting. We find out that the jury was really already impaneled at that particular point. I believe the day of the judge's decision on the prior bad acts was actually the first day of evidence. So there is a timing component. I do understand, probably not my strongest point in this argument that, the defense counsel was totally caught off guard, because I don't think that's totally true, but certainly would change.
Can we just pause on that for a second?
Yeah.
I mean, that seems to, in fact, the third and fourth victims, he was indicted for the charges involving them in 2019, 3 years before this all took place. So he had clear notice for years that he was going to be charged with crimes involving the third and fourth victim, and he presumably had all sorts of discovery about the third and fourth victims. So when this severance and trial happens in 2022, I think, he knows everything that he knows not everything. He knows a lot at that point. So really, notice is not a legitimate point here, is it?
I don't think it's I don't think it's the strongest part of my argument. I'd recognize, but it was something that concerned defense counsel enough to bring it up at the argument that there was some Fifth Amendment issues she felt was involved, and it did impact her trial strategy. At least that's what she argued. But again, I'll shift probably to my stronger points here on the prior bad acts evidence. I'd ask the court to kind of take a look at what the judge did say in his decision. I think there's kind of three instances in which I think that the court kind of abused its discretion. First, there's really no limitations whatsoever on the prior bad act evidence. Bad act evidence is inherently prejudicial. And then when you add the child sex abuse component to prior bad acts, I think it kind of goes to the next level, if you will. I would also suggest that the court's decision really doesn't show any evidence of the weighing the probative value versus the prejudicial impact on Mr. Rosa.
I agree that there's no explicit consideration of that, but both parties briefed the prejudice issue. The defendant argued it orally. Are we supposed to assume that the judge just ignored all the consideration of prejudice and said, yeah, it's probative, I'll let it in? I mean, even on non-prior bad acts evidence, the judges are constantly weighing prejudice versus probative value.
Of course, yes. I'm familiar with the case law that the Commonwealth cited in the brief, and I don't dispute that case law. But I think when you look at the decision on the whole, in the way that how everything progressed at trial, I'd also...
It would certainly be better if we had some explicit discussion from the judge about why the prejudice did not outweigh the probative value.
Right, and I think in a perfect world, I think some more discussion about the probative value would have been helpful as well. I mean, the court found modus operandi, intent, and absence of mistake. And I would suggest, in this particular case, you had AV's allegations. There was 12 charges, and then you had a second victim who had one charge. So I would suggest that, AV and DVR's testimony and evidence standing on its own was really enough to fulfill that. With respect to intent, we're talking about intentional acts here. This is probably not a case where, whether Mr. Rosa's intent was important enough to substantially, or to the point where it substantially outweighed the prejudicial impact. And then with respect to absence of mistake, I didn't see anything in the record that suggested that the defense was pursuing an argument that this was a mistake.
Well, the Commonwealth is clearly relying primarily on common course of conduct. So I guess you should speak to that. The Commonwealth's argument is pretty straightforward, that the third and fourth victims demonstrate a common course of conduct.
Right. So I would just suggest that, this common course of conduct was not necessary for this particular case, where the prejudice to Mr. Rosa was so high.
I mean, all right, slow down. It's not necessary. That's not the standard. The question, if it's helpful, if it's probative, if it's relevant on common course of conduct, then they've satisfied that burden, and then the judge has to decide whether that is outweighed by its prejudicial effect. In other words, you agree with that analysis, right?
I do agree with that,
Okay.
and,
All right.
and I apologize for
So not
speaking
necessary is that is not the right standard. But so if it's helpful, do you agree that it's helpful to the Commonwealth to establish, it's relevant to establish a common course of conduct?
I mean, I think it does have some probative value. I think.
What does common course of conduct mean in this context? I understand where someone's committed a bank robbery, and I think the classic example is, and they kissed the teller on the lips as they departed with the bag of money. And the defendant is known to have followed that exact pattern in 11 previous bank robberies. Now he's on charge for another one, and he says, well, it wasn't me who robbed the bank, but the teller testified that you kissed her on the lips as you departed with the bag of money. So an MO kind of argument. Common course of conduct, I understand the relevance there. But what does it mean in this context, and how is it distinguished from propensity evidence?
Well, I personally, and I've argued in my brief, that I think at the end of the day what this evidence was it amounted to propensity evidence. I don't think that in order for the Commonwealth to prove its case, it needed to establish a common course of conduct. I think obviously it would have helped the Commonwealth, but
What is a common course of conduct? And what does that prove?
I'm not sure I understand your question, Your Honor.
I don't understand the answer to the question, so I'm going to ask the Commonwealth the same question, but I just wanted to see if you could perhaps...
I apologize for not being more
Let me ask you differently. The other half of the equation, prejudicial effect, the word overwhelming seems to be the lodestar here. And you gave a sort of quantitative analysis, number of pages, and the Commonwealth comes back and says, well, they I guess disagree with your quantitative analysis, but also say that these were brief, that prior bad act witnesses, the third and fourth victim, essentially recounted their the alleged crimes briefly, and it didn't have much impact. What's your response to that?
Yeah, so I could respond in two ways, Your Honor. First of all, with respect to the transcript pages, that was one of the standards that was in Dwyer, and I tried to mirror Dwyer because I think Dwyer is such an important case here, and helpful to Mr. Rosa. And secondly, I fully recognize now that I probably should have done a better job of fleshing this out in my brief, because I do think that there's a lot of evidence that pertains more to the prior bad acts, or is equal to the AV's and DVR's allegations or claims. And if I could just kind of run through a little list here that I have. So first of all, we're talking about standalone witnesses. So we had people that came up to the stand and testified, and that kind of creates a real visceral image for jurors that we know from sex abuse cases that it's emotional and traumatic, And just having two more people stand and testify, it can have an overwhelming quality to it. You have the transcript pages, which I pointed out. But if you look at some of the testimony, so the testimony from Martha talks a lot about DFR's disclosure. The testimony from Detective Taylor, he talks about receiving the disclosure from MR. MR talks about giving her disclosure to Detective Taylor, and there's the physical exhibits that were placed in this case. I would suggest exhibits 4 through 16. I think there were 16 total. Many of those are either primarily or mostly related to the prior bad acts. So for example, MR talked about the garage stall and the tool chest. So those were related to her testimony. I think most impactfully was, the pictures of the pubic hair. That related to MR's testimony. So now, as I was talking about before, looking at it from a juror's perspective, here they are in the juror room with pictures of pubic hair. That's quite overwhelming and doesn't relate in any way to AV's allegations or DVR's allegations about the abuse.
Well, they were instructed before each witness testified, correct, the jury?
Correct. So the jury was instructed 4 times about prior bad acts evidence. The first time they were instructed was before AV was cross-examined, and that primarily dealt with the penile vaginal penetration issue. But the 2 other times they were instructed was before MR and before DFR, and then in the final charge. I think that the final charge was problematic in another way too, because the standard prior bad acts language has like 8 reasons why prior bad acts can be admissible. This particular judge found 3 reasons. So if you look at the actual model jury instruction, it says include the ones that were found to be true or relevant for this case. But the judge decided to give all of those reasons, and I think that would make the jury instruction probably more confusing to a juror. And then again, as I talked about before, the testimony from Detective Taylor, the testimony from Martha, that was not, there was no limiting instructions associated with that.
I just want to make sure you know you got 30 seconds left, and you do have 2 other issues. How you spend your time is up to you, but if you want to move on to any of the other issues, feel free.
Okay. Well, I think that the prejudice on Mr. Rosa was certainly compounded by particularly MR's testimony about her opinion that Mr. Rosa was sexually abusing AV. Certainly that type of testimony is generally prohibited and in a way just kind of piled on to the prejudice that was already available in this case.
Follow-up. Circling back to Justice Wood's initial question about joinder, if we were to find error and we're assessing either prejudice or whether there's a substantial risk, we would consider the weight of the evidence, correct? As part of the assessment?
Yeah, under both, yes.
And under both, let's say for victim 1, we have 2 named victims who testified. Victim 1 testified, supporting victim 1 was a sane nurse, and then we have prior bad acts. But when we're assessing the strength of the evidence against the defendant with respect to victim 1, are we also to include the fact the jury convicted victim number 2? In other words, it's almost like prior bad act evidence that was joined. So when we're assessing the strength of the evidence against the defendant, are we to consider both victims' testimony or just one, depending on the issue?
I would say that, the Commonwealth's case in chief was with respect to both victims, so it would be appropriate for the court to consider that testimony of both of them. I would say that the defense did put on evidence specifically to challenge the credibility of AV's testimony through Mr. Rosa's wife, which I think is a little bit unique to her testimony. or that particular victim.
Okay.
Thank
Thank you very much. We'll hear from the Commonwealth.
Morning, members of the panel. May it please the court,
Hey,
Jennifer
Susanne.
Clausen.
Yep, you can come up to the podium,
Thank you.
then you get your light.
Hi. So to address the first argument, essentially the argument regarding whether the judge should have put on the record or in his ruling the exact language that he found the evidence to be more, the probative value outweighs the any prejudicial effect of the bad act evidence. And I'd suggest that, yes, the best practice would to be careful in making that ruling, including that particular language. But it's not fatal to the admission of the evidence. And I quoted Commonwealth versus Samia and Mahan and also Morand in my brief, which set out that it is not necessary for that particular language to be set out in the court's ruling or oral, either written or oral ruling, and it's inherent in the court's ruling on the motion to admit the evidence. So what inherent in Judge Glennie's ruling was his consideration of both the probative value and the prejudicial effect of the bad acts. And
Sorry, which case is that says?
Samia,
Samia, okay,
Yes.
thank you.
and Samia cites Commonwealth versus Mahan, and that's on page 35 of the brief. And again, those cases essentially say it's inherent in the judge's ruling in the tender of an or objection to the evidence in their ultimate decision to admit it. So here there was some consideration of the probative value versus the prejudicial effect. The court cited DeRazio and again and Barrett, I believe, which is the correct language or correct case to cite. And that's also indicated in Moran and Samia that the court cited the correct language, and that shows the consideration of the prejudicial effect in the probative value.
So can you explain what do you think is the strongest purpose or the strongest argument for this being admitted for a probative purpose? And as you know, I'm particularly interested in this common course of conduct idea.
Correct, yes, it would be the pattern of operation common course of conduct.
So what does that mean in this conduct, in this context?
Well, in particular, in sex abuse cases, it comes down to similarity of the abuse of the victims and the defendant's access to the victims.
So how does that differ from propensity?
It's similar to propensity, but we have the bad act law that allows the Commonwealth to admit such evidence that might be considered propensity just based on the similarity. But that's the state of the law, is we're allowed bad act evidence in order to...
Where's the line between, I mean, in essence, isn't it an argument that, well, he did it then, he did it on these other occasions, therefore he must have done it in the charged case as well? Isn't that the reasoning?
Well, it's not the reasoning. It would be to show that the defendant had a particular pattern of conduct that showed his intent. And it's also to corroborate the victims, Commonwealth versus Pillai.
How does corroboration come into it? How does it, a victim complains that the defendant sexually assaulted her. How does it corroborate her testimony that the defendant sexually assaulted someone else on a different occasion?
Well, basically the similarities of the situations here. We have all related females in the defendant's family that he had access to.
So again, isn't that propensity? Well, he assaulted her sister or her aunt or another member of her family, therefore he must have assaulted her as well.
In a way it is, yes.
I don't mean to put you on the spot here, but I'm having a lot of trouble figuring out how this is not essentially propensity evidence.
I mean, that would be the defense arguments in their motions to exclude the bad act evidence, and there is a fine line between propensity and common scheme, pattern of conduct.
And can you tell us why this case falls on the permitted side of the line?
Just under the case law for admitting prior bad acts in this particular case, the defendant falls within those lines of cases that refer to Commonwealth versus Hanlon, where several witnesses were able to testify as to the defendant's prior bad acts in a sexual abuse case. And here it falls in within the lines of the sexual abuse cases where bad acts is let in. So it
okay, so one of those cases, at least, Barrett, 2 incidents were closely related in time, place, and form. Okay, so MR is from 2000 to 2008. That's before the period involving AV and DVR. And then DFR is 2016 to 2018, which is after the period of involving AV and DVR. So does that matter? The fact that whereas AV and DVR, their time frames overlap, these other 2 essentially do not. One's long before and one is shortly after. Is that relevant to our analysis of whether common course of conduct versus propensity?
Not necessarily. There's no bright line test for timing, and it's a prolonged period of abuse. So when there's a prolonged period of abuse throughout the years, the lapse of time between each victim is less relevant to the nexus or the scheme. So again, I mean, there is the fine line between propensity and bad act evidence in common scheme of course of conduct, but it also shows the defendant's intent and negates any claim of fabrication on behalf of the victims. And again, one of the reasons that Judge Glennie allowed the evidence in was also to corroborate the victims, to explain an occurrence that the jury might not otherwise understand, or negate the defense claim that everybody colluded within the family in essence to either support AV or get the defendant in trouble. So again, there's different reasons why the bad act evidence would come in other than propensity.
And that was defense evident from the opening statements, right? Credibility.
Yes, that AV made this phone call, and then after AV's phone call, then other family members came forward. And yes, after her phone call, that propelled the other witnesses to come forward, and their suggestion was collusion between the victims.
What about when we're talking about what you refer to as this fine line in between? In the opening statement, when the prosecutor says this case is about the defendant molesting the children and his female children's family, do you think that crossed a line?
Me being the prosecutor, looking at it now, maybe that was close to the line. I don't think it crossed the line because the jury was going to hear from MR and DFR. So I think they needed to be alerted to the fact that 2 other witnesses were going to testify, and they were going to hear the testimony anyway. So once the jury heard from the 4 witnesses, they would have known that information.
And what about the weight? I didn't get a chance just because it wasn't imperative and we're running out of time, but there's an argument to make, and I think you made it, that it's not apples to apples comparing the testimony in Dwyer to our situation, where in Dwyer there was essentially lengthy testimony about the essential acts, where here there's a lot of background testimony. But you do have, and I believe it's the first prior back witness saying, it happened every single day. Was that anticipated, or at some point should the Commonwealth or should the judge, or who has the obligation of saying, well, I think we've probably hit a point where there's been enough prior bad act evidence?
Well, I think both the Commonwealth and the judge have that obligation. And here I'd argue that the Commonwealth did limit the prior bad acts. There was a lot of testimony.
But she's saying he did every day for years. How did they limit it in that instance?
Well, it was limited in the fact that she explained how it came about, which was similar to how the abuse started with AV. And then she explained in detail the first incident, which again was similar to AV. But then when she was asked, about the other types of abuse, she just said what types they were, and the Commonwealth did not ask her to provide further detail on the abuse. So, and again, it's similar to AV because AV said this happened frequently, pretty much every time she saw the defendant when she was alone with them. So I don't think her saying it every day really exacerbated or overwhelmed the case, just because there wasn't a description of every single incident or every type of penetration or abuse. And as far as the argument, as far as the first complaint, we didn't address that. The first complaint, I'd suggest issues arose out of the defense counsel, trial counsel, essentially asking the witnesses about the first complaints that they had made. So the Commonwealth did not elicit first complaint testimony, and any complaint testimony that was elicited, I believe it was just related to MR telling the detective that.
So if I have the names right, I believe that Martha testified that DFR disclosed to her.
She did, but that was as a result of defense asking her. Oh, I'm sorry. What happened was Martha started testifying. We had to break. Then the prior bad act witnesses testified. So defense had asked DFR about her disclosure to her mom, and DFR had testified that, yes, I did tell my mom, and it was on video recording. Then MR was put back on the stand after the bad act witnesses due to an issue with the defendant not hearing the interpreter.
I'm not talking about what MR said, I'm talking about what Martha said.
I'm sorry, Martha.
Martha
was put on.
testified that
Yes.
DFR disclosed to her.
Correct.
Why wasn't that first complaint evidence?
It was, but that was elicited by the defense upon their questioning of DFR.
So DFR testified on cross that she disclosed to Martha, and then you call Martha, who says on direct, yes, DFR told me.
That's correct. So the only instance where I believe the Commonwealth elicited any first complaint evidence was from MR, who indicated that initially she never said anything during the abuse. It was anticipated by the Commonwealth based on the defendant's motions that they would be asking MR about her being interviewed in the past and never disclosing that the defendant was abusing her. So in order to essentially head that off, the Commonwealth had asked MR if she ever had told anybody and had asked her who the first person she told, and she indicated that she'd told Detective Taylor when this all came about. She didn't go into detail, and I'd cite Revels.
So why isn't that first complaint evidence? I mean, yeah, go ahead.
It is, but she was a prior bad act witness, and I tried to look at it.
So why is first complaint evidence any less subject to the rules laid down in King and subsequent cases when the victim is a prior bad act witness rather than a complaining witness?
I tried to find some law on that. I was not able to find anything related to that. And again, it would be essentially to have the jury assess the credibility of that prior bad act witness. So technically, it could be. Right.
Doesn't that further kind of contribute to the risk that the prior bad act evidence will overwhelm the case or distract the jury from the essential issues? If you're calling a witness to shore up the credibility of a prior bad act witness, that's kind of collateral to the issues in the case, isn't it?
It is, and I probably shouldn't have even indicated in my brief that because they weren't a primary witness in the case of bad act, the first complaint rules don't apply. But I did further explain why this first complaint testimony that MR told Detective Taylor for the first time was not first complaint evidence elicited by the Commonwealth. It was for another purpose, and that's to show the timing of her complaint and also head off the defense anticipated questioning that she had these prior interviews in the past and she never told anybody that the defendant was abusing her, although she disclosed abuse by someone else. So, and that's permissible. Even in King, the Commonwealth shouldn't have to wait for the damage to be done with the witness in order to head off the questioning by the defense. So again, I'd suggest that, yes, technically it could be first complaint testimony looking at it, but it wasn't elicited for that purpose. So as far as the Commonwealth's argument, it wasn't first complaint testimony, and nor were there details given to the officer. So again, I had cited some cases, and also Commonwealth versus Revels indicates, yes, a mention of the abuse to the officer could be first complaint, but there's no harm because there was no details provided. And I'd suggest that no instructions to address the last issue regarding the first complaint testimony was that there was no instructions required here. The court, the Commonwealth didn't offer any first complaint testimony. Again, it was brought out by the defense, but for that one mentioned by MR, and neither party wished to have the instruction upon the court's inquiry. And again, because the Commonwealth didn't elicit the testimony from MR that she told Detective Taylor for first complaint, that was not warranted, and nor would it require reversal based on the fact that that instruction wasn't given. And then finally, we didn't address MR mentioning that she had known that the defendant
Well, we can read your brief on that.
Okay. So,
All right, thank you very much. Thank you
the
both.
rest of my brief.
All right, our third case will be 24P 896, Commonwealth versus Leslie JURCZUK. I hope I'm pronouncing that correctly. Mr. Schnipper, please tell me if I'm not. And again, we will be taking a 15-minute break after this third case.
Good morning. May it please the court, I'm Merritt Schnipper representing Leslie JURCZUK today. The trial defense in this case was a combination of self-defense and a challenge to the Commonwealth's theory of causation. Of these two prongs, causation was the more important issue for the defense because it challenged an element underlying any finding of criminal homicide liability. And as the expert affidavit that's now before this court shows, that challenge was grounded minutely in the facts of the autopsy and other facts of the case. Now, the self-defense component of Mr. JURCZUK's case, which was presented through his own testimony and some adjutant evidence, worked. It was effective in the sense that jurors did, in fact, find that he acted in legitimate self-defense against an attack by his cellmates, albeit, obviously, there's an excessive force component there. But the causation component of this defense, unfortunately, was never presented to the jury. This was critically prejudicial to the defense in two ways. Obviously, the defense went forward without crucial evidence to Mr. JURCZUK's defense, and it did so after counsel had promised that evidence to the jury in opening. Jurors would have reasonably understood when counsel failed to produce the promised expert that she would not have been able to, as he promised in opening, support that aspect of the defense case, and thus that she couldn't meaningfully challenge causation. That, in effect, although it wasn't overtly made to the jury, that in effect was a concession that there was some level of causation through Mr. JURCZUK's exercise of force, and that itself meant an acceptance of a mitigated liability manslaughter verdict, which, of course, is exactly what happened. Now, there's no question in this case that counsel's decision not to call Dr. La Posada was tactical in the sense it was consciously made mid-trial. So the real question for this court is whether that was a reasonable decision or manifestly unreasonable.
So cutting to the chase, why don't we have an affidavit from trial counsel or an explanation of why we don't have an affidavit?
Well, the reason you don't is that the person or the counsel who put together the motion for new trial didn't obtain one and instead basically put in an affidavit about his own conversation with trial counsel into the record. And when I came...
Right, and his understanding of the reason for not offering the testimony doesn't make any sense. Or at least it discloses, I think, two errors or two questionable decisions by trial counsel in that blood wasn't necessary, blood on the floor wasn't necessary to Dr. La Posada's opinion, and in any event, there was evidence of blood on the floor. So, you know, the explanation, the hearsay explanation that comes through in first post-conviction counsel's affidavit relating his understanding is kind of garbled and, you know, hard to credit, frankly.
I agree with that. And the reason...
So why don't we have...
The reason we don't is that when I came into the case, which is after the case had been subject to multiple entries in this court, and I took a look at this file, I said that prejudice and the issues that are really at the center of this motion for new trial cannot be assessed without an affidavit setting forth the substance of the missing expert testimony. And I felt, I think reasonably, frankly, that I had limited ground to fight on. And because we had some explanation, albeit not particularly plausible, as Your Honor states, from trial counsel about his rationale, the most important thing for a judgment of whether this motion for new trial was properly denied without a hearing was to understand what the expert testimony would have been. And on the record that's now before this court, you see that Dr. LaPosada provides a very clear explanation of how Mr. JURCZUK did not and could not, frankly, given the force that's available to just a human body, have caused the fatal injury in this case. And she divides head injuries from the neck injuries she says is the exclusive cause of death. And at this point, I think we have more than enough in this record to justify an evidentiary hearing at which, as my sister points out, both trial counsel are still in practice, and we can summons them in for a hearing at which they will have the opportunity to explain the rationale that they used for deciding not to call her. And we can all...
But so you got you went and found Dr. LaPosada, and
She's not hard to find.
She's not hard to find, and she said, yes, I'm happy to give you an affidavit, and she did. Trial counsel, I believe, are still alive and around, and you could have gone and talked to them and got an affidavits from one or both of them, right?
I certainly could have. The reason I didn't is that I felt I was trying everybody's patience by asking for a fourth remand to the trial court, and I felt I had very limited grounds on which to ask that. So I felt it was important for me to simply go to the very most essential component of what was missing from this case. And I do feel that just Dr. LaPosada says, if you look at Dr. LaPosada's affidavit, there is no good explanation for counsel not to have called her. Now, that doesn't mean that she wouldn't be subject to cross-examination at a hearing. Of course
well,
she would.
let's talk about that,
Sure.
because I'm not sure I agree with that. The defense, as you note, required or turned on the testimony of the defendant, and in many senses, it was successful. He, to some extent, convinced the jury that there was at least a reasonable doubt that he was acting in self-defense. And he gives a very specific narrative. And the narrative he gives is broadly we were fighting, and then there was this bear hug moment, and we both fell to the floor, and the victim, the decedent, pops up and sits in a chair, and then I leave. Okay, so there are several ways in which that narrative, it seems to me, is blatantly contradicted by Dr. LaPosada. First, and I don't want to waste all your time, but the most important one is the table. She says, here's how this happened, in my view. In my view, they come together and they fall, and the decedent's head hits, or neck or chin hits the table, and that causes the fatal injury. She also says he would have been rendered unconscious at that point. So,
That's not exactly what she says. She said, sorry.
well, let's stick to the first part, that I think we all agree that she says, my view is he must have hit the table as they were falling. The defendant makes no mention of the table as they're falling. So that, I think, is a plausible concern for trial counsel when he realizes that there's a contradiction on the fundamental moment of the cause of death. What's your answer to that?
Well, my point is that my answer is simply that what Mr. JURCZUK testifies to is he jumped, we had the first fight, then I'm sitting on the bunk, he's sitting on the table, we're sitting, I think everything's over, then he says, USOB, I'm gonna get you. He turns out the lights in the cell, he comes at me, we bear hug, we grapple, we go down. He says, we hit the ground, and then it was just like over. So there's something
Right, but there's no mention of the table.
Wait, so we're saying that unless he says, while I was being attacked by somebody and I grabbed him and we fell to the ground, I specifically noticed the impact on his chin of this or that, that we're saying that there's absolutely no benefit to being in her. There was some great risk of putting her on the stand, because the issue here is that Mr. JURCZUK he says, he never admits to hitting the guy in the face at all. Obviously, the jury found he did. What Dr. LaPosada is doing is selecting, she says, and you have to take this point first. She says a human being is not capable of producing sufficient force with an arm or even a kick to hit somebody on the underside of the chin and smack their head back so fast and hard that they break their neck. So it must be an impact, especially with no visible wounds at all on the neck. So it must be a situation in which he struck something. She says we can eliminate the bunk because it's a hard metal edge that would have left a line. She says we can eliminate the concrete floor because it's too flat, it can't catch a chin that way. And thus, by process of elimination, we're reaching the table that, of course, is intimately connected to the narrative of this event, that's where Mr. Callahan jumps up off of to attack Mr. JURCZUK the second time. So I don't think it's in any way...
Wait, sorry, I didn't, well, and that's where Mr. Callahan jumps up to attack Mr. JURCZUK a second time. Are you saying that, because I read Dr. La Posada's affidavit, and I read it a few times, to say that that fatal injury occurred in the final confrontation. She has a very specific chronology of events, and she's saying that whacking his head on the table is what killed him, and that was the final confrontation.
Right, because what she's...
So there's no jumping up.
No, well, the final confrontation was that he jumped up, they grappled.
Right,
They,
okay.
Yes. So
Right.
the point here is that there's two separate little conflagrations.
Yes.
And what she is saying is, and she's not saying this because this is what Mr. JURCZUK says happened. She's saying because the nature of this harm to the tracheal cartilage would basically cause you to pass out within a couple of minutes, it had to have been very shortly before the termination of all behavior in this cell.
So I'm saying, I'm struggling with the inconsistency between that very specific narrative and Mr. JURCZUK's testimony that we bear hugged and went to the floor. No mention of the table. That's very different.
It's certainly different, and let's explore that at a hearing. But the point here is that Mr. JURCZUK is fighting in a room in which a man has attacked him. This is the second fight. The lights have been turned out. It's 4:30 in the afternoon on a December 12th afternoon in the Suffolk County House of Correction with tiny little windows. It's a dark room. He doesn't see much, or at least it's plausible that he can't see much. And he's grappling head to head, so something happens, they go down. The idea that the motion judge could simply brush this affidavit aside with no comment, we need to explore this at a hearing. If, in fact, the court doesn't determine that there's such prejudice from the broken promise aspect of the issue that you just grant a new trial now, because to be frank, it's not just a question of the missing evidence. It's a question of what is the prejudice to a defendant from this missing evidence after it's promised to the jury for the purpose of disputing causation. And I think when you have a prosecutor who is arguing with no facts and evidence that this man punched him on the neck so hard that he broke his tracheal cartilage, and you have an omitted expert who is promised an opening who says that's not physically possible for another person to do. We're not talking about Mike Tyson here, although the Commonwealth spends a bunch of time making him sound like the Incredible Hulk. He's a 50-year-old man, and the motion judge says it borders on the frivolous, and you would have lost all credibility with the jury to introduce medical records showing that he had a torn rotator cuff in his right arm at the time of this fight. And we have a prosecutor, and of course that evidence is not introduced, Dr. La Posada is not introduced, so a prosecutor just says this guy so savagely beat this man that he broke his neck with a punch.
Right, well, okay, I mean, you said a lot there, but just to zero in on one piece of it, again, Dr. La Posada's chronology, I'm focused on the rotator cuff. Dr. La Posada's chronology, she indicates the first episode in which the victim's head, I think it's undisputed, is beaten very, very badly. She says did not kill him, but he was beaten to a point where he was semi-conscious, likely suffered a concussion, which didn't kill him. The point she's making is this was not the fatal injury. That's her point. But he was beaten to the point of semi-consciousness, obviously by Mr. JURCZUK. And so that opinion undermines, well, supports the Commonwealth in the sense that Mr. JURCZUK's rotator cuff is clearly not handicapping him from putting a beating on somebody, a very bad beating on somebody. So that's another concern of defense counsel. And what's your response to that?
Our response to that is that's why she is so important, because she says, so he can exert enough force, and she says it could have been his fist, it could have been the floor, it could have been kicks from Mr. Monago, who he describes as kicking the two men when they're down on the ground. So it could have been a variety of factors. But yes, he's significantly beaten. That highlights the prejudice from her absence of trial, because what you need is somebody to say, that's really disturbing, those visual those photos of Mr. Callahan's face. And in fact, we find out that there actually were brain injuries. But she says these brain injuries were not sufficient to cause death. So you can say, no matter how badly you think he might have beaten him, or you even find he beat him, that's not the cause of death. The cause of death is an injury that a human being is not capable of inflicting with an arm or even a kick. So there's some other cause there. That actually completely would support Mr. JURCZUK's testimony, because he doesn't just say we grappled and we went down to the ground. He says, and then it just kind of ended. After that, we went down and nothing more happened. That suggests something traumatic during the fall, because we hit the ground and it was just kind of over.
Right. But clearly what I'm struggling with is Dr. La Posada's affidavit clearly introduces stuff that the jury didn't hear and is contradictory to stuff that the Commonwealth argued. I get that. But the defense, we are, I think, required to look at defense counsel's plausible strategic, tactical reasons for not calling her. And it's problematic that we don't have an affidavit from trial counsel. And beyond that, there are several, in my view, very likely explanations for why defense counsel would not want to call her. Broadly, she will contradict aspects of Mr. JURCZUK's testimony. And how do we untangle that?
You untangle that by allowing me to have an evidentiary hearing on the motion, right? Because the bottom line is, again, and if I I'm not sure that the court would have granted me leave to go back and get a whole bunch of affidavits and do a whole new third round of motion for new trial pleadings. I was basically trying to work the art of the possible in order to make this man's case, because he has been saying since his trial that this isn't what happened. And at some point, this causation evidence needs to be heard by a decision maker, whether it's a motion judge, or the jury. But
now, speaking of possibility of additional motions, the Commonwealth says that the motion judge was perfectly entitled to deny the motion to reconsider because Dr. La Posada's affidavit wasn't newly discovered evidence. It should have been introduced earlier if it was going to be considered. So, I mean, looking, just at the kind of rules governing motions to reconsideration, and I think you acknowledge this in a brief, that's kind of right. But if it was, if that affidavit should have been obtained and submitted earlier, and we don't consider it here on the grounds of essentially waiver, is there just going to be another new trial motion based on ineffectiveness of the first post-conviction counsel?
I mean, how can there not be another attempt? Because ultimately, it's the merits that need to be considered. And even if it's waived 6 ways to Sunday, the merits need to be considered under the substantial risk standard, which is, are you left with an uncertainty about whether the defendant's guilt has been fairly adjudicated? And when you look at this affidavit, the granular specifics in the autopsy, the fact that it's physically not possible for a human being to inflict what she says is the exclusively fatal harm with his hands or feet, and that we're going to simply say that because your lawyer was too late or Merritt didn't get an affidavit from the right person at the right time, we're never going to hear this. You're going to suffer this 18 to 20-year sentence in prison, and never will the core of this crucial aspect of your trial defense be considered by anyone. I just think that is the definition of a miscarriage of justice. You need to consider this forensic pathology testimony on its merits, and if it needs to be subject to cross-examination, let's have a hearing. But to simply say that the door is closed, I think, is a miscarriage of justice. And I see my time's up, so I'll rest on my brief. Thank you.
All right, thank you. Ms. Knight.
Good morning. May it please the court. Erin Knight on behalf of the Commonwealth. The motion judge properly denied the defendant's motions for new trial and reconsiderations where the defendant didn't raise a substantial issue. Here, I just want to make clear to the court that this is actually the reconsideration that we're here on technically is the defendant's 4th attempt to get his arguments regarding the medical records and Dr. La Posada before the courts. In November of 2018, he did a motion to revise and revoke, which was denied, which was all about the medical records and Dr. La Posada. In January of 2021.
I think we know the motions.
Okay.
But what do you say to counsel's last point that, even if it's waived 6 ways to Sunday, eventually someone needs to deal with the substantial risk issue?
Sure. Well, what I would say to that is even though the motion judge here on the second reconsideration, Mr. Schnipper's motion, denied it procedurally, which was entirely proper, he also did consider the merits, though he did not put the merits as the reason for the denial, because that's why we have the procedural ability to deny things. Otherwise, it wouldn't matter. He did on, page 181 of the defendant's appendix, which is page 4 of the motion for reconsideration decision, in footnote 1, he does actually address the merits. He states that although not a ground for the court's decision on the pending motion, the court notes that Dr. LaPosada's theory hinged on the cause of death being a freak injury resulting from the victim's chin hitting the corner of a table, and that on cross-examination, Dr. LaPosada would have been required to acknowledge the extensive, brutal head and body injuries that undeniably resulted from JURCZUK's blows. Trial counsel's tactical decision not to call Dr. LaPosada may well have assisted JURCZUK by avoiding evidence that supported the murder charge.
Can you just give me that again, the record site?
I'm sorry, it's defendant's appendix, page 181, footnote 1. It's page 4 of the actual decision itself.
Yeah.
And so here, even if this court were to remand for an evidentiary hearing, it's quite clear that what Judge Ullman would have done in his third consideration of this claim is on the merits deny it as well. And I would also point back to the motion for a new trial reconsideration 1, which Judge Ullman treated as a motion for new trial because the first one was so devoid of claims in law. He did look at the merits. And if you look at Dr. LaPosada's affidavit that was submitted and the merits of which Judge Ullman considered in the motion for new trial, they line up. Really, it didn't say much of anything different besides, I guess, the exact hit the table with his chin.
Well, that's kind of the critical point, as I understand the defendant's argument. And he says, you know, with regard to what the judge said in that footnote, it's not a freak injury. It's not something that's a 1 in a million that left no trace but still might maybe create a shred of doubt. There was an observed bruise underneath the chin, I believe, in
Yes.
whether it was autopsy photos or otherwise. So, I mean, this seems like a pretty quick brushing aside of a fairly substantial affidavit.
A fairly substantial affidavit that alleges that a injury occurred that was not testified to by the defendant himself, and a theory that would have had to stand alone. Dr. LaPosada's theory would have been an island. Nowhere in her theory does she talk about the blood on the floor, which was consistent with what the defendant's testimony that they both went down together, consistent with the Commonwealth's medical examiner that the victim hit his face off the floor.
But how is the presence or absence of blood on the floor an obstacle to or important to her theory?
I don't think it's necessarily an obstacle to her theory. What I think was the tactical decision, and again, we look at the tactical decision at the time it was made. So this is after the Commonwealth's evidence was presented and after the defendant himself testified, the decision to not call her was made. Looking at it at that time, putting her on the stand where they had theories of rush to judgment, self-defense, and I would argue they did put forth a third-party culprit with Mr. Monago, putting her on the stand to bring in a totally new theory, a theory that has no support in the defendant's own statements.
It's only new if you ignore the fact that the defense counsel argued it in the opening. I shouldn't say argued it, previewed it in the opening.
He did, but he didn't to the extent that the jury were relying on it for the exact issue or the exact testimony which Dr. LaPosada was supposedly going to give. And again, going back to the second claim about calling her, it's not ineffective assistance just for not calling her after promising or after stating it they would in closing. I would point to Nardone, I would point to Duran, and again, it was 15 days between when the opening was given.
Well, but I think he's pointed to two kinds of prejudice. One is the promise made but not kept, and the second is the substance of what he believes should have been offered.
But again, if you look at the substance of what she says in her affidavit, the way that Judge Ullman analyzed how the trial went and the testimony at trial, the defendant's theories, that their main theory was rush to judgment, at no point did the defendant ever mention anything about a table. And I think to put on a completely new theory of what happened here, one, again, that stands alone with no testimony to back it up, no evidence to back it up besides this expert's own opinion, to challenge the Commonwealth's medical examiner and to challenge the defendant himself. I would also point out that whether or not this was...
Wait a minute, sorry. To challenge the Commonwealth's medical examiner, my recollection, correct me if I'm wrong, this is, I could be wrong, but the medical examiner basically thought that, or opined, that the subdural hematoma from the beating likely was the cause of death.
That and the tracheal injury.
Right,
It was
but in fact, Dr. La Posada illuminated that first part was wrong. No ifs, ands, or buts, just wrong.
Correct.
So to the extent she's, I mean, so you don't want to, it seems to me relying on the medical examiner is deeply problematic.
Well, when I say relying on the medical examiner, counsel used it in cross-examination to support the defendant's theory of hitting the floor and how this was a tussle and how they were together going down on the floor. It would also, the medical examiner did talk about how he'd only seen the type of neck injury in severe car accidents and things like that, but he didn't rule out that a human could do it. So I do understand how La Posada may have challenged that, but given the overall situation that we're looking at here, given the fact that we're looking at the time of the decision being made, the time after the defendant testified and what counsel had La Posada there for, we're looking at that discrete time, whether or not that tactical decision was manifestly unreasonable. And here, where they were, the main theory was rush to judgment. And I think if you look at defense counsel's closing, you'll see the main theory was rush to judgment. Here, self-defense obviously also played a key role where...
Doesn't this theory mesh nicely with the rush to judgment in that she's saying the medical examiner, or not she, well, defendant would be arguing at this point, calling Dr. La Posada, the medical examiner got it wrong. Our medical examiner, or our former medical examiner, says the cause of death was not the head injuries, it was the neck injury, which could have been inflicted in any number of ways in a fight in this confined space. And I mean, it's part of, the very paragraph in which trial counsel discusses La Posada's anticipated testimony says, what you're left with is the theory fueled by a rush to judgment and an incomplete, flawed investigation. So I don't see how Dr. La Posada's testimony would have been an island. I think it seems to fit with the other themes of the
It would have
defense.
been an island again because there was no mention of the table, no mention of that sort of injury.
Well,
I would
there's
also
really
state...
only one person who could have, I suppose Monago was gone then, right? So he couldn't have mentioned
At some
it.
point, towards the second half,
I mean,
yes.
the defendant never said, oh, no, Callahan's chin never hit the table. He wasn't asked about that, was he?
That's true, but he did give his own version of events. And I would say, again, a trial counsel who's dealing with his own his own client's testimony on the stand, and a medical examiner who's already testified that lines up with that theory of events when the rush to judgment and self-defense were already presented. I would also state that Dr. La Posada, as Justice Wood pointed out, would have had to grapple with a cross-examination regarding the injuries of the fact that he had contusions around the head, face, and neck, a subdural hematoma, bleeding on the brain, a fracture to the tracheal cartilage, a fracture of the hyoid bone, excuse me.
Well, that's not
He
really
also
a
had...
strong point on cross-examination because that's at the core of her testimony on direct. That's what caused it.
But how do you then get past the excessive self-defense when the guard who knows this man comes in and sees him on the floor and he's unrecognizable because of the blows that have been administered to him by the defendant?
I'm trying to reorient a bit. First of all, I feel like you should address the promise, the broken promise. Give us your best case that a broken promise like this is not prejudicial.
Sure. So again, the cases that I cite in my brief, Duran and Nardone. I would also point to, I'm going to say this wrong, but Commonwealth versus NE or NG out of the SJC just this year. I would also point out that at base, promising or talking about an expert in an opening and not giving one in evidence is not ineffective assistance of counsel in and of itself. In fact, the case in which they found that this was a problem, which I believe was Duran, or it might have been Anderson, that my brother cites, Anderson, it's stating that the defendant actually gave his closing argument after the rest of the Commonwealth's evidence. So he didn't do it at the beginning as we do here in the Commonwealth. He waited until the Commonwealth's case was presented and then gave that opening. So it was much more close in time. And in and of itself, it's a tactical decision. Things change during trial.
I don't think anybody's contesting that making a promise in an opening and then not keeping it is not per se ineffective assistance, because of course circumstances change and tactical judgments can change during trial.
Sure, and if you look at Nardone, that's exactly what happened. As the evidence came out,
And the
they had
question
to switch
is that what
gears.
happened here?
I'm sorry?
And the question is that what happened here? Was there a not manifestly unreasonable reason for not calling
think
Dr.
absolutely.
Laposada?
I think
If there was, then the broken promise is not ineffective. If there wasn't, then the fact that not only was she not offered, but that she was promised and then not offered, compounds the prejudice. I think that's what the defendant's arguing.
I do understand that, but again, the decision to support your own client's testimony with testimony that has already come out, the evidence at trial, the photos, the autopsy report, and instead of putting on somebody that would have to acknowledge that the defendant caused these injuries of him being unrecognizable, the Commonwealth's medical examiner, again...
Would that have been so difficult where she says, yes, those were terrible injuries, but they didn't cause the death?
Yeah, and then you get a battle of the experts, which is fine, but I would also state that you then still have the defendant's own testimony that does not jive with that.
Right, but what's wrong with Attorney Schnipper's point that we should sort this out with an evidentiary hearing? We're speculating, it feels like we're all speculating about the real question is defense counsel's analysis at the time of trial. I've heard from Dr. Laposada, I've heard from my client, and anything more I say at this point is speculation. Why isn't it appropriate to have an evidentiary hearing to figure out the best answer to this question where somebody's doing 18 to 20 years in prison?
Because it's the defendant's burden and he didn't meet it. Here, to procure an evidentiary hearing, it's the defendant's burden to put forth a substantial issue, most of the time supported by affidavits that are not just the defendant's own. Here, Mr. Grossberg did not do that at first and then put on his own affidavit of his conversations with counsel. Here, Mr. Schnipper put on the affidavit of Dr. Laposada, but at that point, Judge Ullman had already considered this issue and had not found it substantial. And again,
right, but sorry, you've gone back to Judge Ullman. I guess honestly, I just don't agree with Judge Ullman. That doesn't mean that
well, it's not whether or not this court disagrees with him. It's whether or not it was an abuse of discretion.
Let me be more specific. Dr. Laposada, I'm focusing on this footnote. Dr. Laposada would have been required to acknowledge the extensive brutal head and body injuries that undeniably resulted from JURCZUK's blows. Justice Sachs, I think, has already made the point I'm making. That is misunderstanding the importance of Dr. Laposada's one of the important points of Dr. Laposada. She's saying that beating is not what killed him. I'm confident that beating is not what killed him. So Judge Ullman, with all due respect, you're misunderstanding one of the crucial points of Dr. Laposada. And so my point is just simply, that's not helping me decide this.
Okay, so perhaps that's your reading and perhaps Judge Ullman's reading was different. However, what you still have here is the fact that Dr. Laposada's testimony here in and of itself was considered by the motion judge, and he still decided not to have that hearing.
But why? But why is that
because
reasonable?
Because it was procedurally proper to deny it where it's been brought up 4 times already.
Well, okay, let's assume that I don't like that idea, that argument. Let's assume that I agree with Attorney Schnipper that waiver in the context of liberty is a really bad argument. Let's assume that I'm concerned about the substance of this decision. What's the reasonable substantive answer to not having an evidentiary hearing? To avoid a substantial risk of a miscarriage of justice.
Because you have to look at the trial, excuse me if I may finish. Because you have to look at the trial as a whole. It wasn't Dr. Laposada and self-defense were not the linchpin of the defendant's entire case here. In fact, his rush to judgment was his main theory, and self-defense clearly worked here because it was mitigated down from second-degree murder to voluntary manslaughter. And so here, Dr. Laposada may have been a plus, and he can argue that it would be a plus factor to, that hindsight shows that could have done something. However, the standard is if the decision was manifestly unreasonable and if the judge abuses discretion in finding a substantial issue was raised.
All right. Thank you.
Thank
Thank you both. Very well argued on both sides. We will take our 15-minute break now, and we'll be back after that for the final three cases.
Court is open. Please be seated.
All right, we are back in session for our 3 civil cases. The first of which is 24 P 1249, Bonarrigo versus LEKACH, if I'm pronouncing that correctly. And it's Mr. Brandwine?
Yes, Your Honor.
Yes.
May it please the panel, good morning, I think, still. My name is Zach Brandwine. I am counsel for Defendant Artcan. I am joined at counsel's table by Howard Goldberg, counsel for Mr. Carton, and Mr. LEKACH in his personal capacity is in the courtroom. I am happy to answer any of the panel's questions right off the bat, but the issue in a duplicative damages case that's presented here is, one, whether there is a single course of conduct and a single harm, and two, whether there was a limiting instruction given to the jury in the matter.
Well, yeah, I do have a couple of questions right off the bat. First of all is, even assuming that the implied covenant claim and the fiduciary duty claim, as it was essentially narrowed by the jury, when they rejected the usurpation theory, even if those related to the same injury, the judge had reserved for herself the decision of relief on the fiduciary duty claim. So once the jury came back and said 400, 400, and the judge said, are these duplicative here? Let's ask the jury, because obviously defense and plaintiffs disagreed about that, and the jury said no. The judge then went ahead and adopted the 400 for the fiduciary duty, but the judge had reserved that for herself. Couldn't she have awarded more monetary relief or some kind of equitable relief? And hadn't she already announced her view of the evidence that she thought that plaintiffs should get $1 million each? So in essence, why is she limited to the jury's valuation of $400,000 for the freeze-out? She already said she thought it was worth $1 million each.
That's a fair question, Your Honor. I'm happy to address it. So number one, the judge made no independent findings of fact, right? And the context in which the judge confirmed the jury's award on the second breach fiduciary duty claim is really important. The jury comes back with a verdict slip. The parties and the judge view the verdict slip as presenting the issue of duplicative damages. Plaintiff's counsel objects. The judge sends the question back to the jury. Jury says, no, they're separate. The same basic error with respect to the absence of a limiting instruction still applies at that point. I want to get to Your Honor's point. I just think the context in which this is happening is very important.
We got the context.
Okay.
Yeah.
So the jury comes back, says, no, they're separate. Same error exists. At that point, jury's dismissed. Judge and counsel engage in pleasantries. And almost as an afterthought, plaintiff's counsel says, well, Your Honor, aren't you, what's going on here?
The judge gave defense counsel plenty of time to think about it. He said, are you sure? Yep, we're satisfied. So the judge would you agree that the judge at that point was not bound by the jury's assessment that the freeze-out, whether considered under fiduciary duty or implied covenant, was worth $400,000? The judge had already, in fact, announced she thought it was worth $1 million each.
But she made no findings about that point, Your Honor. There's no other way to read the record.
She's not required to make findings, is she? Particularly when she says, defendants, I'm going to adopt what the jury said. And, what do you think of that? And the defendant said, we're satisfied with that. And the judge says, are you sure? I mean, I could consider awarding equitable relief.
But again, I think the context, everything that's happened before is really important. The judge essentially says,
but look, was the judge free to award more relief than the jury did for the exact same injury?
She might have been, but again, there's no way to read the record. Why
wouldn't she have been? Assuming the evidence supported
I think
greater relief than the $400,000.
This is the point I'm trying to arrive at, Your Honor. There is no evidence in the record to support anything other than the $400,000 award.
Well, the plaintiffs had a number of theories as to why the damages should be greater or the relief should be greater, and the judge herself had already stated several times that she thought the plaintiffs should walk away with $1 million each. So are you saying there's no basis for awarding more than $400,000?
But she did award $400,000.
Yes, but couldn't she have awarded more?
Maybe, but that's not what happened.
So is it an abuse of discretion that prejudices your clients if she awards less than she could have?
No, but again, Your Honor, I don't think there's any way to read the record and what happened in this case other than the judge adopting the jury's finding about the $400,000 award, and there's no evidence in the record to support anything other than the $400,000 damage figure propagated by the defendant's expert on the business valuation at the time.
Well, is that really true? I mean, your opponent makes the point that there are lots of different valuations out there, and dilution, after you factor in dilution, there are a lot of different ways to get to $800,000. I mean, I understand your analysis was your single expert, but they point out even your own expert gave, I think, 3 different versions, but that there were different ways to come to a valuation of something closer to a lot more than $800,000.
Oh, there were a lot of different ways to value the damages in this case. There was the only connection to the $400,000 is the defendant's expert on valuation. And that testimony, or that evidence derives from the expert's valuation of the company at the time of the freeze-out in May of 2016.
I understand.
At the time the breach occurred and the harm is fixed.
Your brief is very clear and well done, and I understand crystal clear the argument. It was really well done. But the problem is your opponent's brief is also crystal clear, and they say, we disagree. There's a lot of different record evidence. You both cited record evidence that I checked, and you're both correct that all these things happened. And so, but my takeaway is there's a lot of disagreement about what the jury could have found.
But you have to go back to the record. And again, what is the connection in the record to the $400,000 figure? There is only one piece of evidence that comports or ties closely with that amount.
Okay, that may very well be true. Let me ask you this. So the judge thinks to herself, and she's not keeping it to herself, she said it on the record, I think the evidence supports $1 million each. There was evidence from the plaintiffs that could have supported that. There was also evidence from the defendants that supported $428,000 for total. Once the jury says $400,000 each, is the judge limited in her awarding of equitable relief to what the jury said it was worth, or was she free to award more? Not maybe as much as she thought the evidence would justify, but she's giving, it goes to the trouble of having the jury give an advisory verdict, and the jury says $400,000. She says, well, I'm going to basically double that. I'm not going to go as high as $1 million each, but I'll go to $400,000 each. Who could complain about that? Is that inequitable?
Your Honor, I can't disagree that as a legal principle, the judge is at that point free to award the damages that she sees fit. But again, you have to go back to the record. You have to go back to what's happened in the case. And what is the connection between the $400,000?
Let me finish.
Yes,
for
sir.
what purpose do you need to go back to the record if at that point the judge is free to award the damages that's greater than what the jury did? What more do we need to find out from the record?
She's not free to award duplicative damages, Your Honor. There is the inquiry for the court.
But she's free to award more. You would agree with that?
No, I would not agree with that, Your Honor. She cannot enter an award that's duplicative.
I agree she can't enter an award that's duplicative, but where she believes that the damage or the harm to the plaintiffs was $1 million each, and the jury says no, $400,000. Is she limited by the jury? She said the jury was advisory. Everyone knew that all along.
There's a much closer connection between the $400,000 and the record evidence submitted by defendant's expert and the awards that were entered in this case, and that evidence supporting that is duplicative damages than $1 million or the $800,000 total that was awarded, and the figures that the plaintiffs have tried to sort of reverse engineer from the record.
Can I ask a different question? Waiver. I want to talk about waiver very briefly. It seems that I count up 5 different points where your side could have requested duplicative damages instruction. There was no request for a duplicative damages instruction, 1. Number 2, the judge's proposed instructions, there was no objection. 3, the actual charge, there was no objection to the actual charge. Then it gets even more serious for you, I think, on the question of waiver. The number 4 is after the verdict comes in, the judge says, oh, we forgot to give them this instruction, and I'm going to ask them right now, is this duplicative? no objection from your side. And then fifth, which I think might be most fatal, at least in my mind, after this happens, and this is really getting at the same discussion we were just having, but in a different way, reasonable tactical decision. Do you have any objection to this, counsel? We're no objection, and then RA 5205, we're satisfied with the verdict. And in the context of the judge quite clearly saying, you know, this is advisory, I could take it out myself. And it seems, what I'm reading from the cold transcript is your side saying quite sensibly, no, we're good, thank you very much. Why is that not waiver?
Let me take each of those instances in turn.
Sure. If you could start with the last one, because I think that's the critical one.
I'd actually just like to frame this within the context of the case law first. So Charles River Associates, or Charles River Construction, excuse me, and the Sazala line of cases stand for the proposition that a objection to the absence of a limiting instruction on duplicative damages does not constitute waiver of the issue on appellate review.
Right, it doesn't constitute a waiver of the duplicative damages issue, but where the judge said, I'm going to award $400,000 to each, or else do you want me to decide it myself and give you a written decision, and the defendants say, no, we're satisfied with the verdict, how can you come up now and say, we're not satisfied with the verdict, or we're not satisfied with the judgment?
Let's start when the jury comes back. Jury comes back, judge recognizes there's a potential duplicative damages issue. Defense counsel says, I object, we have an issue of duplicative damages here. The question goes back to the jury. It still lacks the limiting instruction. Again, I return to Charles River and Sazala line of cases. Maybe an instruction at that point would have helped clarify things further, but in terms of preserving the issue for appellate review, no further objection at that point is needed under the Sazala line of cases.
Maybe not to the absence of an instruction, but where the judge says, this is what I'm going to do. Do you object? And the defendants say no. How can you come up here and say, oh, but we object after all? I don't understand where at what point did you say to the judge, no, don't award $400,000 on each claim. These are duplicative. And the judge said, I disagree with you. At what point did you tee up that issue for the judge to decide, and the judge said no?
The question goes to the jury. The answer comes back from the jury. No, they are separate. At that point, the trial judge says the issue is cleared up for appellate review. What further objection is necessary at that point to preserve the issue?
Well, if she said your objection is preserved for appellate review, that would be very different. But she said, let's ask the jury. That will clear it up for appellate review.
Your Honor,
I'm having a hard time seeing how, that will clear up what the jury thought.
But the case law is very clear. There are no magic words required to make an objection or preserve an objection.
Right. The issue has to be fairly presented to the judge. Where did you fairly present to the judge your argument that notwithstanding the jury's insistence that these were not duplicative, they are duplicative?
But at the point where the trial judge says, well, it's preserved for appellate review or it's cleared up for appellate review, I don't think there's any fair way to read that in the context of after a 5-week trial, you're at the end of the day, and you've made this objection on the record, the question's gone to the jury, it's come back, and the trial judge says, okay, we've got the issue framed up for appellate review. Parties go on to discuss pleasantries, and almost as an afterthought, plaintiff's counsel says, look, Your Honor, you are entering the jury's award, correct? And given the context, everything the judge has said prior about her view of the case, she says, do you want me to enter my own judgment on this? Because it could be greater. The defense counsel at that point saying, no, we're done here, is not a waiver of the duplicative damages issue. It is them tapping out and saying, no, Your Honor, we don't want you to increase the damages award. We understand the duplicative issues.
What would be the fear
having been preserved?
Why would there be any legitimate fear of the judge increasing the award if the evidence wouldn't support it? Let her go ahead and increase the award even over what you say are duplicative damages if you still got your argument that it's duplicative.
Your Honor, I don't know that you could walk out of the courtroom and talk to your clients and say, oh, yes, I objected, and the judge increased the damages award from $400,000 to $2 million, right? If you are defense counsel at that point, and you have heard from the judge that the issue has been cleared up for appellate review, it is absolutely the reasonable and plausible interpretation of the record to understand that that issue, the duplicative damages issue, has been preserved, no further objection is necessary, and the conversation at the very end of the transcript...
If no further objection is necessary, then why does she ask if you have any further objection to her to her adopting the jury's verdict?
I can't speak to what was in the judge's head, Your Honor, but again, that conversation is not about duplicative damages. That conversation is about whether the judge is going to hit them.
Why then doesn't counsel say, no, we don't object to it, Your Honor, preserving our point that we made previously that that the damages are duplicative?
That would certainly make my argument in life here a lot
You,
easier.
this is not a technicality.
It's not.
And the reason it is, and I just want you to appreciate this, is that we don't have the judge's take on whether these damages were duplicative or not, because the defendants never said, Judge, notwithstanding what the jury said in its answer to your supplemental question, we think they're duplicative, and here's why. How can an appellate court go through a 5-week trial and decide, oh, these damages are duplicative, when we don't have the trial judge's perspective on that?
Your Honor, there is no doubt that in hindsight, my life would be made much easier if trial counsel had said, no, Your Honor, I just want to ensure that I'm preserving this duplicative damages issue for appellate review. I want to make that very clear on the record.
Yeah.
But
and
that's
at that
not...
point, at that point, the judge would have said, okay, either, yeah, you're right, they are duplicative, or here's why they're not duplicative. And then we would have a starting point, but we have no starting point.
Sure, but that is, I just want to, this is really important. That is not what the case law requires. Charles River, and this is all a line of cases, where no one objected to the absence of a duplicative damages instruction, there is no basis in the case law to find that the conversation at the end of the trial constituted a waiver.
Can I ask a follow-up? So your opponents, again, high-quality representation here, address this specifically, and you don't file a reply brief, so I would just want to hear your thought. Oh, I'm sorry. I apologize. You may have answered. You may have answered this already, but they say that in Charles River, the SJC is affirming the trial court, and here, likewise, they're asking us to affirm the trial court. Broad discretion, in a nutshell. What's wrong with that analysis?
The Charles River case, again, stands for the proposition that no one in Charles River objected to the duplicative damages issue. No one in Charles River objected to the absence of a duplicative damages instruction.
And then the judge, kind of sua sponte after trial, if I'm remembering right, said, hey, these damages are at least overlapping, and reduced it.
Yes.
So you had a judge's ruling with a memorandum of decision, I believe. That allows the appellate court to do some review. Here we don't have that.
Again, Your Honor, I think you have to look at the record. All these lines of cases about duplicative damages stand for the proposition that the appellate court can reach the record issue and investigate whether there was a single course of conduct and a single harm for which damages were awarded twice.
Okay.
Thank you for the court's time this morning.
Thank you. We'll hear from the plaintiffs. Mr. Torres, is it?
Torres. Yes, good morning,
Torres.
Your Honors. May it please the court. Stephen Torres, with my colleague Ryan Rookie with me. We represented the plaintiffs, Scott Bonarrigo and Mark Thomas, and we represent the appellees here. Let me sort of start with the issue of duplicative damages. We do know that the judge did not believe the damages were duplicative because the trial court entered the total amount of $800,000. At the end of the transcript, she says, okay, $800,000, that's it. So we know that the judge didn't think the damages were duplicative because she wouldn't have entered the judge.
Agreed, but we don't have her rationale or her explanation for why they're not.
I was there.
Or do we?
I was there in the exchange. Everyone was content with the way it was resolved, and we haven't sort of just read the jurors' plain words. When the counts came back with $400,000 for each of the two counts, there wasn't a specific question in the verdict slip that said, are these the same damages under breach of fiduciary duty as for the breach of the implied covenant claim? That question had been included following the contract count and the implied covenant count. So the judge instantly realized that there was the potential for a disconnect. She conferred with counsel, and everyone agreed that the way to address this was to ask the jury. So that's what the judge did, and when she posed the question to the jury in the moment, one of the jurors literally answered the question in open court and said, no, they're not the same. And the judge cautioned the jury and said, we're going to send you back. It took a grand total of 7 minutes for the jurors to leave the courtroom, fill out this note from the jury, come back, get questioned by the judge, and the foreperson had the note, handed it to the judge, read, the jurors all concurred. No, they are not the same, $800,000 total for the plaintiffs.
Here's what would make it a lot easier for me. If in plain English, somebody could say, articulate how these things are different. I think Attorney Grossman makes a fair point when he's saying there's only one theory of harm here, the freeze out.
Yes.
And I was constantly struggling throughout all of this briefing to articulate the difference between the two theories here, and I couldn't do it in my own head. I understand everything you just said. I heard that. The
Sure.
judge and the jury seem to think they're different things, but I keep coming back to what's the difference analytically?
So it is absolutely one body of damage. It is damages for the freeze out, and it totals $800,000. And the jurors in this instance opted to put it between two counts instead of just including it in one count.
So I think what I'm hearing is the damage is $800,000.
Yes.
And we're just going to, rough justice, just split that between this one over here and this one over here, right?
Yes.
We're not going to worry about the analytical niceties.
Because
Is that it?
that's correct.
So if they just said $800,000 for one, we wouldn't be here.
We wouldn't be here. That's correct.
Okay.
There were two counts, and they found in favor for the plaintiffs on both counts, and they chose to divvy up the judgment amounts in two counts. There's nothing that precluded them from doing that, because what would have prohibited that result is if they were duplicative. But we know they're not duplicative because the judge asked them, and they answered the question and said literally, no, they are not the same, $800 total for the plaintiffs.
I hear your opponents saying, yes, they are. They are duplicative. That you're just saying they're not duplicative. And
I'm not just saying, Your Honor, the jury is saying they're not duplicative.
The jury did say that.
And the trial judge is saying they're not duplicative because she entered a judgment for $800,000.
Right.
And in the moment when that happened, the defendants agreed with, and Your Honor, I appreciated you listing out the number of waivers that have occurred here, which we completely agree with. But the most important waiver is the final one. Once we've now polled the jury and we know that the damages are $800,000, when the judge says that clears it up for appeal, there's a reason that this 2.5 to 3 week trial took 5 weeks. Everything was contested, and the judge anticipated that there would be appeal. But I believe, and how I interpreted it, is by saying that clears it up, meaning that clears up this issue. It's one less thing that we'll be fighting about, because now here we are 3 years later arguing about whether or not the damages are duplicative when the jury literally said, no, they are not the same. So they had an opportunity right then. If they thought it was still duplicative, it would have been preposterous to say it, because the jury had just said that it wasn't. But in any event, they agreed, and they said they said that they were content. They had no issue with it because the judge was prepared, and it wasn't an afterthought. Yeah, there were pleasantries exchanged at the end of the trial, and we appreciated that exchange with the court, but we knew that there was this issue that was still live and needed to be addressed, which is the judge had said it was an advisory opinion only. So she wasn't bound to it, and we certainly were cognizant of the fact that the judge had on multiple occasions demonstrated, in our view, her opinion that the plaintiffs had clearly been frozen out, and that the damages that they had sustained were greater than the $800,000 that the jury said.
Can I ask you just a kind of linguistic
Yes.
question here? We're using the shorthand term damages, but we're talking about relief, equitable relief.
Yes.
And usually those two don't live in the same universe. So can you tell me, what is this monetary compensation? What does it represent? Is it restitution? Is it disgorgement? Is it something else?
In this instance, it is similar to contract damages. It's the benefit of the bargain. They formed a venture, and their ownership interest in this venture, we'd say, was worth.
So I know that under cases the parties have cited that the court has broad discretion in fashioning equitable relief for a breach of fiduciary duty in a closed corporation. But what is the nature of this relief? Is it what typical existing category of equitable relief does this order to pay money fall into?
Yeah, it's, the judge is allowed to give monetary damages for this, for breach of fiduciary duty. This is our interest in the company that we were denied, and for their breach of...
I'm not questioning the substance so much as I am just the terminology. I mean, does the SJC say a court can award damages as equitable relief for breach of fiduciary duty?
Breach of fiduciary duty can include monetary damages. That's not an issue that they've raised on appeal, so we haven't briefed that. But certainly, breach of fiduciary duty can and often does come with an award. Here, the award, in our view, constituted the monetary damages associated with the freeze-out. And I need to be able to touch upon this notion that my brother continues to say it was $400,000 and it has to be $400,000. There's nowhere in the record that they can point to that comes to the calculation of $400,000. That number doesn't exist. The number that they continue to most closely align with is the defendant's expert testified to many different methodologies. Business valuation, oftentimes there are three. They use the market approach, the cost approach. So many different methodologies. One of his calculations comes out to $428,000, not $400,000, $428,000. There's nobody who testified that the damages were $400,000. Instead, he gave several calculations. One was $428,000, another one was $727,000, and a third was $127,500. Well, that $800,000 that the jury found is well in the middle. If you average those together, you get $800,000. I
think your third, just for the record, your third one you said was $127,000. I think you meant in excess of $1 million.
Thank you, Your Honor. $1,275,000.
Yeah,
so if you average those together, it's just over $800,000. And in fact, we can get it even closer because if you take the plaintiff's expert, what he valued the enterprise at roughly $42 million.
Right, but I know what you're going to say.
Right.
We read this. I mean, I take your point. I think it's a good point. That complicated analysis where the jury could land at exactly $800,000, I would have been shocked if the jury actually did follow all of that, but who knows?
It comes pretty close, right?
Right,
We got
but
it
I
down
understand
to $500.
your point. I think we all take it
Yeah.
as well taken. The plaintiff's experts gave valuations all over the place, but higher than $800,000.
Yes.
And then in certain ways, exactly at $800,000. A lot of different valuations.
That's right, and the jury was allowed to credit the testimony. They could average together the plaintiffs and the defendants and then use the dilution, because here the judge was very careful, even though she didn't give the duplicative damage specific instruction, and we'd say because they didn't ask for it, the instructions she did give, both on the specific counts, specifically said that the plaintiff should be made whole and nothing more. She specifically instructed the jury that they not punish the defendants. And then and she said that specifically in her general damages instruction. So the jury was very much instructed and was very much cognizant that they should only make the plaintiffs whole and they should not punish the defendants.
Is that in Charles River? Does that distinguish this case from Charles River?
It distinguishes the case from Charles River. You're absolutely right, Your Honor, because in that case there was no damages instruction, and in that instance the trial court took it away. Here the trial court certainly didn't take it away. The trial court entered the $800,000 and wouldn't have done so if she deemed them to be duplicative. She didn't deem them to be duplicative because the jury had said they're definitely not the same, and she entered the $800,000 judgment after the defendants said that they were content. Because the plaintiffs, we would have been happy to have her consider the breach of fiduciary duty as an advisory opinion only, have her issue her own opinion, and to Justice Sachs's point, she had other relief available to her. She could have given us an ownership interest in the successor entity. She had that, and she specifically was cognizant of that. She had asked what the plaintiffs wanted for damages, and we said at this point, instead of the relief being a potential option of getting a part of the company that they would prefer, it had been several years later, that they would prefer money damages. So she had that available to her and specifically didn't undertake a written decision or a further finding because the defendants had said that they were content with the outcome. So now to come into court after having agreed there and avoided what the judge could have and we believe would have done is now the equivalent of, having your cake and eating it too. And we'd say there's no basis to say that that the damage awards are duplicative when the jury had specifically said that they were not. And the cases that they cite are certainly not on point to our situation here, where the trial judge took it upon herself and rightly, with the consent of counsel, employed a methodology by simply polling the jury that was prudent, sensible, and timely, and remedied any issue that could have existed. And there's no case that they cite that's like this one. They also referenced the Sala v. Locke SJC decision. On that instance, the trial judge in that case refused to poll the jury. So it's completely different than our circumstances here, where the judge recognized the potential for a disconnect, asked the jury, and the jury in no uncertain terms said that the damages were $800,000 total, not $400,000. So unless Your Honors have any further questions, we'll rest on our briefs.
No.
Thank you.
Thank you. Thank you both. Okay, our next case is 24P1298, Edward P. O'Neill III versus Birch Hollow, LLC. Whenever you're ready. Mr. Barker?
Attorney Gallant.
Oh, I'm sorry.
Attorney Barker was with me, my associate.
Apologize. Thank you.
Thank you, Your Honors. Your Honor, we represent the plaintiffs in this matter. The appellant, we're here appealing the judge's decision of July 30th, 2004, as it appears to both of these defendants in both hearings. And the fundamental error in this decision as to both of these defendants is the judge applied the wrong standard. The judge applied a summary judgment standard in both of these circumstances, rather than a motion to dismiss standard, and rather than the applicable standard under the Les Pendleton statute.
But there are all sorts of technical problems with your appeal. Why don't we start there instead of the standard of review? So on lis pendens, you want to start with lis pendens?
Sure.
So they point out no verified complaint. You say, well, we had 2 verified complaints, but I want to make sure I understand this. The judge allowed the motion to amend and replace the verified complaint with the second complaint, which was amended complaint, which was not verified. So that takes the place of those verified complaints. And so therefore, at that moment, when that motion to amend is allowed, you don't have a verified complaint, and therefore you have no longer satisfied the statutory requirements, which must be construed strictly, for lis pendens. Where am I wrong?
The wrong is that the Les Pendleton statute requires one or two things. One is a verified complaint. The second is a complaint which is verified by subsequent affidavit. In this particular case, we not only had one complaint, we had 2 complaints, we had 3 complaints, all the way up to the second amended complaint. All 3 of those are verified. At the time,
why does the one that the judge allows, which is not verified, not stand in the shoes of those, make those a nullity?
Well, first of all, I don't think it does. I don't think it does make it a nullity. I think the fact that there are existing verified complaints that substantiate all of the facts of the complaint set forth by the plaintiffs is enough for Les Pendleton that withstands this case. I don't believe that there's any case law that says because you have a subsequent complaint that's not verified, it eliminates and wipes out the 3 other complaints that are verified on the same allegations. But nevertheless, let me address one question, and that is, we have an affidavit that we filed at the time of the hearing by the plaintiff that is in the record. We filed 5 affidavits. One of those is Ed O'Neill's affidavit, which goes through the complaint and verifies the allegations of the complaint of the pain and penalties of perjury. The judge doesn't address that affidavit.
What's the record site for that affidavit? It's all right, we'll find it. Don't worry about it.
It's the affidavit. I'll give you the site. 615. I can give it to you before the end of the argument, but there are 5 affidavits of record which the court never addresses, the court never reviews, the court never adjusts, and the court doesn't consider as part of her decision. There's an affidavit of Ed O'Neill filed with the proposed amended complaint, which goes through the allegations of the complaint. In the statute, the Les Pendant statute says in the alternative, you don't have to file a verified complaint. You can file a complaint that sets forth a separate affidavit verifying the affidavits of the complaint, going through the affidavits of the complaint. And his affidavit does that. It went through the allegations.
The one I'm looking at, 650 to 655, his affidavit is dated April 10th, 2024. That's after the judge had issued her,
No, it's before the hearing.
okay.
The hearing is July of 2024. They were filed months before then, and they were presented before the court at the time of the hearing. Okay. So at the time of the hearing, we had both 3 prior verified complaints, and we had an affidavit of Ed O'Neill. And we indicated to the court, if the court had asked us, it was intended that the proposed amended complaint would be verified. She didn't allow that complaint. She struck the complaint in terms of the defendant Hauser, so that complaint had to be refiled, which we did. We refiled the complaint and we included a verification, but the subsequent court struck that because it wasn't included with the original motion. So subsequent to that, we filed another complaint with a verification attached to it, even though we have an affidavit of the plaintiff in this matter. All you have to show in Les Pendants is 2 things. You have to show that you have claimed an interest in real estate, which nobody disputes in this case, and you have to show that the allegations of the complaint were verified. And we've done that in 4 separate occasions in this matter.
So another procedural problem is the lack of a notice of appeal in the Registry of Deeds within 30 days. Your argument, as I take it, is that that only applies to ex parte lis pendens, and reading the statute, I disagree with you. So is there anything other than statutory construction?
No, our language is specifically based upon the language of the statute. Under Section D, which is the section of the Notice of Appeal, it reads, any party aggrieved by a ruling under subsection C. Subsection C is an ex parte aggrievement, ex parte motion denial or approval, or the denial of an ex parte motion for memorandum of les pendants may appeal pursuant to this section of 118, Section 231. That entire section only applies in the event of approval or denial of an ex parte motion for les pendants. Nowhere in that section does it say if your les pendants is dissolved by an evidentiary hearing or a hearing before the court that you have to file this notice of appeal.
So is that the kind of decision appealable?
Yes, it's appealable based upon the fact that it's interlocutory on this particular case.
So
we believe it's a final determination because separate judgment is entered on that path.
I mean, separate judgment was entered dismissing the complaint against Hausler, but...
Yes, not against Gaudet's, but we believe that decision is appealable because it's the final determination of les pendants.
You can get review by a single justice under 231-118, paragraph 1, but how is the dissolution of a lis pendants appealable to a panel while the case is still going on?
We believe that's a final decision on the les pendants, an error of law that we can appeal based upon her decision. So we've taken the position.
Do you have some case saying that a dissolution of a lis pendants is like essentially sorry, the term is slipping my mind now, but effectively final?
No, I haven't brought a case before you in our appellate. I didn't anticipate that argument, so I can certainly look at that and provide something supplemental. In this particular case, what the judge did in her decision is she based her decision on the credibility of the evidence and assumed facts. For example, in this particular case, the relationship between these 2 parties was always a lender-borrower relationship. It went back to 2014. Hausler was my client's attorney. Hausler did all the documentation. Hausler introduced Gaudet and then did the documentation. In the prior transactions, Hausler did have a disclosure saying, I represent the lender in this particular loan, so therefore you've waived any claim. In the transactions in the real estate involved with this case, the 3 or 4 different real estate pieces, there's no such agreement with Hausler. Hausler was the attorney who represented my client in acquiring the properties and negotiating the agreements for the properties, and then he went to Gaudet to do the loans for these properties, and Gaudet changed the deal in 2018.
I think we have the facts. I don't mean to cut you off, but here's my question, cutting through all of this. These are real estate deals, yes. And apparently this odd ownership process where Gaudet buys the property, Gaudet gets title to the property, and then somehow that your allegation is that ownership interest transfers to your client. And there's a reference here to the writings that in one of the many versions of this telling, he says his wife's company handled the documentation. Wouldn't it have been, why do we not have the documentation for the purchase of these properties?
We do. They're attached to the affidavits that we submitted in the case. Each offer, each purchase and sale agreement involved with all three of these properties were in my client's names. Now, what happened, Hausler, at some point in the process, the agreements and the offers that were to O'Neill or to A.P. Schneider securing all three of these properties were somehow changed to Gaudet. And they were changed to Gaudet with no consideration other than he decided to take title in his name. My client received no consideration for that. Why would my client, who wants to build his house on this house in this lot in Westford, say to Gaudet, you could just have these properties, why don't you just pay me for these properties? Which there is no evidence of that, by the way. This allegation that he paid O'Neill for constructing these properties and that was the deal rather than this loan transaction, there's absolutely no evidence of that. These payments stopped.
I'm trying to find the purchase and sale agreements, and I see we have the affidavit, we talked about that already, RA 650 to 655. Exhibit A, these exhibits, you said, are the purchase and sale agreements. The ones I'm seeing are not signed.
No, there's executed ones attached. There's 5 affidavits that are attached right after Ed O'Neill's. There's an affidavit of the brokers, there's an affidavit of the other broker, there's an affidavit of the engineer, there's an affidavit of Ed O'Neill, there's an affidavit of me. Attached to all 5 of those are the offers that are signed, the purchase and sale agreements which are signed, and the subsequent agreements to those to Gaudet that's there. That shows that all of these properties were secured by my clients, the deposits were paid by my clients, and that the deal was Gaudet insisted that these loans be put in his name, he'd take title to these names. Now, they claim they did that because O'Neill had these judgments outstanding and he was trying to avoid creditors. Again, that's absolutely not true. Mr. O'Neill is a plaintiff in this case. If he was trying to avoid his creditors, why would he be the assertive plaintiff in this matter, number one? Number two, the reason why these loans were placed in Gaudet's name is because Gaudet was a private lender. He had an entity called BIRCH HOLLOW. BIRCH HOLLOW lent monies under the banking regulations. You can only make so many loans per year. So Gaudet at some point decided to keep these loans and keep title to the property and keep track of what these loans were separately. Every single correspondence that's attached to my complaints, RA 0224, between these clients refer to these transactions as loans. Mr. Gaudet's emails and Mr. Gaudet's text messages say, hey, when are you going to refinance my loans? Have you paid the taxes on Westford Road, on Westford?
But as I understand it, what's before us, at least in part, is the dismissal of all claims against Hausler. So I want to ask, the judge said that the complaint didn't allege how the plaintiffs were harmed by Hausler's alleged dual representation or his conflicts of interest.
Let me address that specifically.
I'm sorry?
Let me address the Hausler action specifically because I think it's a very simple argument. There's 2 complaints for the court to look at regarding the allegations of Hausler. There's the second amended verified complaint, which is of record, which was pending at the time of his motion was brought. But there's also the motion to amend the complaint and the proposed amended complaint, which is
so there's an issue of futility. So assuming that we look at the proposed second amended complaint, which I think is in the record appendix filed by one of the appellees.
Yes, SA 0051. If you look at that complaint, if you look at that complaint, there is no way that this court could make the determination that that complaint doesn't set forth sufficient allegations and prima facie allegations against Hausler on every count.
Okay, so tell me specifically.
We've alleged...
What is the harm that is alleged from Hausler's dual representation or his conflict?
So what Hausler did in this particular case is he represented both parties. There's no letter of conflict representing one party versus the other. He drafted all the documents regarding these transactions. And then when the dispute happens between the 2 parties, he takes the side and says, I'm going to represent Gaudet now against your interest. And by the way, your interest, which I know because I'm your attorney, is no longer valid. These aren't loans. Gaudet owns them, so get out of the property and leave, and you owe us this many millions of dollars of damage. So his loss is he loses both properties as a result of what Hausler did in this particular case.
Why is it as a result of what Hausler did? Isn't it decisions that the Gaudets are allegedly making or made? Hausler is just the attorney.
Hausler owes my client a duty of responsibility, fiduciary duty, and duty of loyalty with regard to his representation.
Even assuming that he breached that by going over and representing the Gaudet interests exclusively, how did that harm your client?
Well, because my client relied on his attorney to protect him in this situation and in this environment and regarding these loans.
Once it became clear that Hausler wasn't protecting,
that was
what was the detrimental reliance that occurred while your client thought that Hausler was representing them, and in fact he had kind of gone over to the dark side?
The detrimental reliance was that these were loans that he was occupying the two properties. One of them is his principal residence, and the other one was a commercial development on Makepeace Road in Westford. And once the dispute happened between the parties, Hausler changed teams in the midstream. All we have to allege in this case is we have to allege a prima facie case for a breach of contract. We allege there was a contract between Hausler and my client. We've alleged there was a legal representative.
Contract for representation.
Again, this is a motion to dismiss standard, so all we have to do is plead a prima facie case. I don't have to prove the case beyond a reasonable doubt.
I'm trying to get clear. The contract you're pleading is a contract for him to serve as their attorney.
Yes, and the complaint specifically alleges that.
So how did I'm still not understanding how his alleged violation of his duties, fiduciary duty or loyalty, or his negligence in representing your clients, how did that harm them?
Well, he didn't do any documents to document that these were loans as opposed to a purchase transaction of ownership. So his negligence in that representation caused all of the harm in this case. If it wasn't for his representation, my client would have documentation of this transaction, of these agreements.
Is that alleged in the complaint, that it's Hausler's failure to document these as loans that led to the harm?
It's alleged in the complaint that Hausler breached his duty to my client and that he had conflicts of interest regarding the relationship between these two parties.
But we don't rely on just mere recitations of the elements of a cause of action. We need specific factual allegations that raise the right to relief to a plausible level. So where is it alleged specifically that it was Hausler's failure to document these as loans that led to the harm to your clients?
I want to move on to this point, but I want to set forth clearly.
I want you to answer that.
In the proposed amended complaint.
Can you just stop for a sec? Can you answer that question, where that was specifically alleged?
Yes. In the proposed amended complaint 0051, it is alleged specifically in counts that Hausler's actions caused my client damages. Again, we have to allege only that Hausler's actions or inactions based upon his representation caused my client harm and suffered damages as a result, and we did that.
All right. Do you say that you did allege that it was his failure to document that caused the harm, or do you say that you didn't need to allege that?
I don't recall whether that specific allegation is in the proposed amended complaint. I can tell you with certainty.
So you can't point to a specific record appendix page where that's alleged. Hausler failed to document that these were loans, and that's what led to our harm.
I can tell you with certainty that the proposed amended complaint alleges that there was a legal contract between him and Hausler, that Hausler breached that contract and my client suffered damages as a result. Whether it specifically alleges the failure to document these loans or not, I don't recall.
Okay. Well, if you can find that specific allegation anywhere in the proposed Second Amendment complaint, please write us in a letter.
I will.
Within 10 days, letting us know what those sites are.
I will. No problem. With regard to the allegations,
Time is almost up, so I just encourage you to.
Oh, all right. Let me see if I can address some of the allegations. The Gaudet complaint in this matter, which I really haven't addressed so far, she's dismissed not only the less penance, but she dismissed the permanent injunction based upon the allegations of credibility. She determines credibility as the factor in this matter.
What's the authority for us hearing an appeal of the dismissal of preliminary injunction?
Again, it's a final order on the preliminary injunction that it's the same theory as regard to the denial of the less pendants. We're claiming that we were denied an interlocutory order and that this court can review that final decision. I guess it's the final decision. In this particular case, again, she determines that the only difference between the second amended complaint and the third amended, or the proposed amended complaint, is that we added a party. We added E.P. Schneider. Everything else was the same. Judge Wallow, in this case, awarded a preliminary injunction and awarded the less penance based upon the complaints that were pending. There's no difference between those complaints other than we added a party, and we specified the allegations against Hausler in that proposed amended complaint. That alone does not negate our likelihood of success on the merits of our claim or the two issues of this matter, namely whether we had a likelihood of success on the merits. That only applies, by the way, to that claim of injunction. The claim with regard to the hardship argument, they argued that the hardship now balances in favor of them. We disagree completely. My client faces losing his primary residence and all the interest in both these parcels of land worth millions of dollars. Mrs. Gaudette, they claimed the trust doesn't have the money to pay the loans on the property. However, we found an affidavit specifically rebutting that. There's an affidavit with the lender where Mr. Gaudette specifically says, I have the money and the cash to pay off these loans, but I chose not to do so. So there's no hardship on Mrs. Gaudette. She had the money. Certainly the trust that owned the property was merely a nominee trust and wasn't funded to pay off those loans. That was never the intent. But Mr. Gaudette had a loan entity and assets to be able to pay that off, and his own words in his own email to the lender says, I have the cash to pay off this loan. So there's no financial hardship for him. Does the court have any other questions?
I'll give you one more minute to finish up, because I recognize we've asked you a lot of questions.
And my summary with regard to the Hausler matters specifically relates to that proposed amended complaint, in that I can't imagine how the court could review no mention of the proposed amended complaint in her decision. She just claims that the actions are futile. She claims the letter of Hausler is protected by the litigation privilege. It's not. It wasn't done when there was any pending litigation claim. And counsel argues, well, the eviction action was pending at the time. However, Doug Hausler says in his letter, I don't represent them with regard to the eviction action. I represent them with regard to anything else.
Isn't it pretty clear that the dispute over the alleged loans was kind of coming to a head?
We sent the letter.
Couldn't litigation reasonably have been anticipated?
We sent the
by
letter.
Hausler and the Gaudettes at that point, even if not by your clients?
It could have been, but it doesn't apply to Hausler because Hausler had dual representation in this matter. He doesn't deny that at times during the course of this entire relationship, he represented the plaintiff. He's the one that negotiated these agreements. He's the one that drafted these agreements. He's the one that prepared these agreements and went to the boards for the approvals of these permits regarding these properties. He can't now say, oh, I'm going to send a letter and it's protected by the litigation privilege. The litigation privilege doesn't apply when you have a dispute with your own attorney. That is still an actionable claim for representation, so that doesn't apply. And the claims are not futile in this matter. The claims set forth every element of every count that we've alleged against Hausler with specificity is in the proposed amended complaint. And I think by itself that withstands any motion to dismiss. What this court did in her decision is she treated it as a motion for summary judgment and said, well, Hausler says he represents Gaudette, so that's it. So the rest of it's futile and I dismiss the claims. That's basically and essentially what she did in this case. She didn't look at the complaint and say that whether these counts, and nowhere does she go through every count of the complaint to say whether that sets forth a sufficient cause of action. Okay. She just dismisses them.
All right.
Thank you.
Thank you. We'll hear from Mr. Covino, is it, for 10 minutes, and then Mr. Waters for 5?
Thank you, Your Honor. Yes.
And you represent Mr. Hausler, correct?
Yes.
Attorney Hausler?
Yes. If it may please the Court, Will Covino on behalf of Attorney Hausler. Just to address some of the initial issues raised, the trial court's decision was well-reasoned, 21 pages. It went through every count. This was not a situation where she applied the wrong standard of review. There's 3 issues in my brief that I want to discuss briefly with each of you. The first is the issue of waiver. Massachusetts law is clear that if you're going to raise an appellate argument, you have to thoroughly brief it and you have to give support. Nowhere in the appellant's brief does he argue how the factual allegations in the second amended complaint plausibly suggest an entitlement to relief. He doesn't even attach a copy of the second amended complaint that was before the trial court to give this panel the opportunity to make that assessment.
Well, we have it before us, so.
Totally understood. You have it before you. I do think it's more than just a technical issue, though. You know, we haven't had any chance to respond to his arguments as to what that is, and he's basically asking the panel to create his arguments for him. Putting that aside, obviously we have arguments on waiver for the motion to dismiss issue as well, and the way the facts were not properly cited anywhere in the statement of facts, along with other procedural issues. But let's get to the merits of the claim, because that's really what we're here for. Even if we assume all of the facts are true in either the amended verified complaint or the second amended complaint, there is no cause of action against Attorney Hostler under any theory. The primary thrust of the initial complaint was a contract action, this loan dispute. And in the amended verified complaint, what is alleged is that Hostler breached this loan agreement. The problem is Hostler wasn't a party to the loan agreement, and that's acknowledged by my brother in his opposition to the motion to dismiss. The only argument that he really has is there's some legal service agreement, which is not alleged in the amended verified complaint anywhere. And when you get to the second amended complaint, if you review it, it's not alleged in any meaningful detail to understand that there was an attorney-client relationship and what the scope of that attorney-client relationship was in order to determine if a breach happened. You have very generic references to conflicts of interest and ethical violations, which, as the panel knows, as a matter of law, is not in itself a breach of the standard of care. But to Justice Sachs' questions earlier of what's the causal harm? And the answer is there's none. Because when you look at the amended complaint and even the second amended complaint, and I would direct the panel to RA 31, which is the first amended verified complaint in which Hostler allegedly sits in on a meeting between Gaudette and Mr. O'Neill where they come up with this scheme of we're going to make this oral contract. Hostler allegedly says to them, put it in writing. And then the next paragraph goes on to say the parties refused to put it in writing. So there's nothing Attorney Hostler could have done at that point in time if he says put it in writing and they don't put it in writing. And then with respect to this whole insurmountable conflict of interest, when does that happen? That happens when Mr. O'Neill hires a new lawyer, Attorney Galat, who sends a letter saying we want to be paid on these loans, this eviction action is what it is, and Hostler writes back. At that point in time, there's no harm because Mr. O'Neill has his own counsel. There's no special knowledge my client has about the agreement here. The agreement is they sat down and they said, we're going to do this 14% in 2 points for these properties. You'll hold ownership. And then when I'm done with my work, I'll get paid. I mean, that's a dispute any lawyer in the Commonwealth can handle and not something specific to my client. With respect to the next set of counts of allegations, it has to do with the misrepresentation claims and the fraud claims. And there's really 2 claims there. My brief sets them out, but I'll hit them briefly. One has to do with Attorney Hostler's representation that BIRCH HOLLOW will perform in the future. And there's plenty of case law, we cited it in our brief, just dealing with the idea of you can't reasonably rely on future conduct, especially when it's about what somebody who the speaker doesn't control a third party says. And I can think of a whole set of situations where I represent clients as a lawyer, and they say, Will, I'm going to do this in the future, and I sign a settlement agreement hoping they will. And if they do it, they do it. But the next day they might wake up and say, you know what, I'm not going to do it. My finances have changed, my situation has changed, I'm not going to do it. Nobody can reasonably rely on me telling any other lawyer what I think my client will do in the future.
They might be able to rely on it as a contract if your client, if there was a settlement agreement in which your client promised to do something.
Yeah, they can rely on the fact that the settlement agreement exists.
That would be a contract claim against the client, but not a fraud claim against you for saying my client promises to do X.
Yeah, I think that the slight nuance there, Your Honor, if I may, is the idea that they could promise that my client will agree to this now. Or the situation, my client has the funds available to do it now. But what my client may do in terms of honoring the agreement 5 years from now, I mean, I can say it, but I don't think anybody can truly reasonably rely on that. My client will agree to it, sign it, and if there's a problem, you can enforce it, but that's not the lawyer's. He can only speculate ultimately whether the client will follow through with the issue. I think that's one of the representation claims. The other representation claim this panel just addressed, which is the representation in response to what I call is a demand letter. Mr. O'Neill has hired counsel. There is a dispute about these loans. What's happening? Are the loans going to get paid? Who owns the property? And there's an eviction action pending. Although I hear my brother saying, hey, Attorney Hostler represented Mr. O'Neill, at that time he surely didn't. He wasn't representing Mr. O'Neill in any capacity. He was clearly on the other side saying, according to Mr. Gaudette, there's no understanding of this agreement. There's an eviction action pending on the subject property. You need to leave. That's exactly what the litigation privilege is designed to protect, is a representation by a counsel concerning a matter that is more than likely going to go to litigation and did go to litigation. The remaining allegations against my clients knew no better. There's a civil conspiracy claim against my client. There's no allegations anywhere in the complaint about my client agreeing to some common plan with the Gaudet defendants to have him do all this work and then not transfer the property. There's no allegations of that. And the brief says, hey, look at my impressive list of facts. And those all have to do with actions that BIRCH HOLLOW took about charging an excessive or usurious interest rate. It has nothing to do with Gaudet and Hostler getting together to form some type of agreement contrary to Mr. O'Neill. There's no allegations that my client had any actual knowledge of Gaudet not honoring the deals in the future. That's not played with any level of specificity. And then the final claim, obviously, is one of Chapter 93A, which is just derivative of the other claims. And if the other claims fail, so does the 93A claim. The final issue before the court, Your Honor, it was briefed in our brief. It wasn't the focal point, but in peri delicto. The idea that you can't ask the court to help you when you're doing something either illegal or doing something wrong. And the public policy reason is twofold. Courts are not designed for that, and we want to deter that. And there's plenty of case law where somebody has done something inappropriate, and the court says, we just can't help you. And that's the case here. Despite what counsel might have just relayed to the court, there's plenty of representations in the record of what the purpose of this deal was. Mr. O'Neill was underwater. His company went bankrupt, and he had a personal judgment against him for over $300,000. And so the idea here was, if we put title in the Gaudet defendant's name, our judgment creditors will never know. And the reply brief makes it clear that we're not hiding the 8-ball on this. That was the plan. It just wasn't my plan. It was the Gaudet's plan. But either way, that's not the point. The point is you have a plan where you're trying to avoid paying judgment creditors. That is not what this court is to enforce. So the court should simply leave the parties where they're at and affirm the decision on that basis as well. And I would point the court to two different issues where there's really no dispute that that was the purpose of this agreement, one being the appellant brief, page 12, and the other being RA 31, talking about the whole point was to allow the continued buying and construction of properties for a profit as a result of, quote, the judgment and bankruptcy. There's no real dispute that that's what was going on here.
Just so I'm clear, does the list pendants relate exclusively to properties that were owned by the Gaudets, not by Hausler?
Yeah, I don't believe, as far as I'm aware, Your Honor, Hausler has no ownership interest whatsoever in any of these properties.
And what about the preliminary injunction? Did that apply to Hausler or?
Not in any regard, Your Honor.
Okay, so the fact that the 54B judgment was entered in Hausler's favor doesn't bring up the lease pendants or preliminary injunction issues?
No, Your Honor. The 54B relates solely to what I believe is a unique subset of claims against Attorney Hausler. And with that, Your Honor, I believe the issues have been waived. The pleadings are meritless. The court did an excellent job, in their opinion, of going count by count. And even if there was some claim that existed, I think in peri delicto squarely applies to this case and resolves it. Absent any further questions from the panel, I will rest on my pleadings.
Actually, counsel, let me just ask you about reasonable inferences based on facts alleged by the complainant in the second amended verified. He alleges that Hausler represented him. You would dispute that, but that's an allegation we take as true.
He says that as the conclusion, Your Honor. If there's an attorney-client relationship, we're supposed to disregard those. There's no real factual basis of, I asked him to represent me on this particular matter, and that's what he agreed to do. And I think that's part of the problem, because that then ducktails into how is there a breach.
It says he represented him in the acquisition and agreements for Emerson Ave, other addresses, including 46 Pleasant Street. We'd accept that as true, though.
That is true, Your Honor, but this isn't about the acquisition. This is about a loan contract.
We accept as true that he says that there were all these oral agreements for loans, including loans for that property, including that Hauser would lend to him, but that Gaudet would lend to him, but the Hauser was aware of all these loans, correct?
Yes, there's no,
and
we accept the pleadings as they are.
He alleges that when he was prepared to take proper title to pay off those loans, that Hauser suddenly denied the existence of any agreements, correct?
That's what he alleges, yes.
So we're to take that allegation as true as well at this stage, correct?
Yes.
And that's not a legal conclusion. That's a factual statement he's making that you disagree with, though.
Well, I think the legal conclusion is whether there was a representation, because I think what you're getting at is, did he switch teams? And the question is, well, what team was he on to begin with, and in what capacity? And was he on the team of, I'm just going to acquire the property, versus on the team of, how are we going to deal with these loans? I think are two different issues. But then I think you then have to go down the rest of the analysis of, okay, you switched teams, there's a conflict, let's assume that's true. Is it the breach of Rule 1.9 or whatever it is of the Master Rules of Professional Conduct, is that actionable? and does it cause harm or does it cause damages? And I think the analysis falls off the track once you get to that next level. But I agree with what you're saying in terms of what the factual allegations are.
And those are matters for fact finder.
I don't believe so, no, because this is a motion to dismiss and motion to amend on futility, so we're accepting those, the well-pled factual allegations versus legal conclusions is true. It's just where that gets you, I think, is the problem.
Okay.
Thank you all.
Thank you. We'll hear from Mr. Waters.
Thank you. May it please the court, my name is Charles Waters. I represent the Gaudet defendants. And I'd like to start where this bench started, and that's on questions relating to the list pendants issue. And Your Honor, I think, raised a point whether there's standing to bring this up to the appeals court. I think Your Honor was thinking about the present execution doctrine.
Thank you.
And I agree, there is no standing to bring this under the present execution doctrine and no case law. So this court can rule on the other issue relating to Attorney Hausler, but does not have to rule on this issue. Second, I want to respond to, I think, a couple of questions Justice Wood raised. One relates to General Laws, Chapter 184, Section 15C and D. And I agree with Justice Wood, your comments that you don't think that that statute applies, that there was a requirement to file a notice of appeal. It wasn't fleshed out in the back and forth with my brother counsel, Your Honor, but I think it's important to note that in that statute, it specifically does address the special motion to dismiss. So when there is an unfavorable ruling on a special motion to dismiss, that 15D applies, which requires the notice of appeal.
Regardless of whether it's ex parte or
Correct.
Right.
Regardless
Right.
of whether ex parte.
Right.
And in this case, that matters. In this case, it matters because there was, in fact, a special motion to dismiss. And this July 30th, 2024 order actually is an order on the motion for reconsideration of the special motion to dismiss and the preliminary injunction issue. So ultimately, the decision on the reconsideration is a decision on the special motion to dismiss, and the decision was to dissolve it. That triggers 15D, and then there's a requirement to file a notice of appeal in the Registry of Deeds, and plaintiffs agree that they did not do that. I do want to also mention that I don't subscribe to the theory that I believe my brother counsel floated to this court, and that is that you can have multiple operative pleadings and that the trial court somehow, after allowing the proposed operative pleading, somehow should look at other filings and other operative pleadings, and somehow that applies.
Is this just for purposes of whether the second amended complaint was verified?
That's correct. Right.
So in effect, a verified complaint is an affidavit. So does that affidavit go away because a superseding complaint is filed that repeats the same allegations but isn't verified?
Well, there's two answers to that. Yes, I think you only can look at operative pleadings. And the second one is, especially this one, because remember what happened here. Mr. O'Neill, in October of 2022, filed a verified complaint saying there was a verbal agreement between me and Mr. Gaudet relating to these three properties. I really own these three properties. I, Edward O'Neill, the plaintiff, I own these three properties. That there were loans relating to this verbal agreement that were given to me somehow under this oral agreement, and that not only do I own them, not only are there loans there, but I also live in one of those properties. So all of this was under one verbal agreement. The second the first amended complaint, the second operative pleading that was filed, and that was filed in April or May of 2023, and that was also verified. And in that verified pleading, he also alleged the same thing. Again, it was me. In this operative pleading, the proposed second amended complaint that was not verified, he has an entirely different story. And that different story is, oh no, that verbal agreement wasn't with me at all. I don't own that property. It was my wife's entity that owns it. And my wife is entered into the verbal agreement, not me. This is not just a small little change in a verbal agreement. This is a completely different case where suddenly the plaintiff, Ed O'Neill, says, verbal agreement wasn't with me at all. I don't own this property. This other entity owns the property. So
That's the basis of Justice Campbell's decision.
Yes, and that's exactly it. And that probably dovetails with the preliminary injunction issues, Your Honor. And that is that the court weighed these things. And when the court looked at issues like likelihood of success on the merits, the court did look at credibility. And the court had a problem with the fact that he renounced in his proposed amended complaint, he renounced his 2 verified complaints. Now, I think that was done strategically. I think there was a reason why we're here with a non-verified complaint, because he didn't want to verify a complaint that would then be used against him because he filed 2 other verified complaints saying something totally different. So I think there's a reason why we're here, a strategic reason. But in any event, the judge said, I've got a problem with this amended complaint, renouncing his positions, upon which, by the way, he got a lis pendens and got a preliminary injunction because the trial court relied on what he was saying, that now he's saying it wasn't true at all. So that's a problem. And the second thing is the court looked at the deposition transcript that I took of the plaintiff, where I went through each of the 3 properties and I said, tell me everything you recall about all terms of your verbal agreement relating to this property. I exhausted his memory and all of this. It's in the record. I highly recommend that the court review that. I exhausted his memory on each of the verbal agreements on all 3 properties. He didn't come close to spelling out a meeting of the minds on all material terms of these 3 properties, $1 million properties, $1 million properties. So, and the court agreed. The court reviewed that, and the court said in its order, I agree, he doesn't come close to establishing a breach of contract action. So that's why the preliminary injunction was properly entered, and the court should affirm the decision.
All right, thank you. Thank you all. And our final case of the day is a partially impounded case, Santos versus Smyth, 24P 671. Counsel, thank you for your patience. I know we've run a little over time today, and I just caution you not to disclose any of the impounded information during the argument. So, Mr. Xavier?
Yes, Judge.
All right.
Yes, Your Honor. Good morning. Good afternoon. Good afternoon. My name is Michael Xavier. May it please the court. I represent the appellant, Devon Santos, along with Katie Walsh from my office. And we are here today, Your Honor, requesting that this court vacate the trial court's judgment of contempt dated March 5th of 2024. One of the main reliances we have in support of our position is the In re Birch case, which this court is familiar with. This was a contempt action, and as In re Birch states, in order to find a defendant in civil contempt, the plaintiff has the burden, must show by clear and convincing evidence that there has been a clear, undoubted disobedience of a clear and unequivocal command. It is our contention that with respect to the 2 orders at issue here, that wasn't done by the plaintiff or the court.
The father argues that you didn't argue in the trial court that the separation agreement or the temporary order weren't sufficiently clear to constitute a clear and unequivocal command. I looked through the record to see if I could find where you made that argument, and I couldn't. So am I missing something? Is father missing something?
I think father's missing something, and I think the argument is flawed and disingenuous because by the very nature of a contempt proceeding, the defendant doesn't have any burden. The burden is incumbent on the plaintiff to demonstrate by clear and convincing evidence that there is a clear order and there's been a willful violation of the clear order. The plaintiff, the defendant, has no
Well,
burden
the
to
judge
clear.
obviously concluded that your client had done so, applying the clear and convince, the standard of BIRCH HOLLOW. So I'm just trying to get a handle on whether you ever argued that the separation agreement or the temporary order did not meet that standard.
There was an argument at the trial court that the temporary order with respect to another language about the spirit of some of the, that was argued at the trial court level.
And the judge agreed with you on that.
And the judge agreed on that. There was no argument.
So we know that the judge had the idea that the order needed to be clear and unequivocal in her mind.
She did. She did. But there was no argument, Your Honors, that was raised that the parenting schedule provision was clear and unambiguous. But again, by very nature of in re BIRCH HOLLOW, it is incumbent upon the court and the plaintiff to demonstrate that there is a clear and unequivocal order and that clear and unequivocal order was disobeyed by the defendant in this case.
Maybe I misheard you, but I thought you just said there was nowhere where it was argued that the separation agreement or the temporary order were clear and unequivocal. Did you mean to say there's nowhere where it was argued that they weren't clear and unequivocal?
I misspoke. I apologize.
Okay.
That's correct.
Thank you.
So it is
but to make this more concrete, I'm at RA 58, and I think this is the operative language that everybody's arguing about. The parties shall work together to ensure that the parties, and only the parties, always have unrestricted access to the child's location. I think that's the central order, and the question is whether that's clear and unequivocal and whether there was a violation of that order. So do you agree that that's the central issue?
With respect to the Life 360, there's two central, with respect to the Life 360, which is one of the two issues. One issue is the parenting schedule, and the other issue is the Life 360.
Yeah.
With the Life 360, my understanding was that there were actually two issues. One was to ensure the access, and one was there was an allegation that my client worked with the child to disallow him from having the phone turned on and off. That was, but the only evidence that the court relied on in terms of opining or deciding that my client did not ensure that was that there was a spare phone in her home, and there was no direct evidence that this child had access to that phone, that she gave the child that phone, that she told the child to turn the child's phone off. So there was some speculation that the court relied on in hanging her hat on was whether or not my client did violate that provision. I don't disagree that that provision is a clearer provision, Judge, but my contention...
There's also record evidence that the child had a computer, and that I don't remember, but what the record evidence that the mother could communicate with the child on the computer, and perhaps locate the child using the computer. Do you have any answer about that?
About her ability to locate the child with the computer?
Yes.
I don't recall that that was an issue at the trial level. I would imagine that this child had access to other phones, maybe friends, other families. But, you know, the question is whether or not my clients took any action to violate any existing court orders. And if I'm looking at the temporary order, she was obligated to create a Life 360 account, which she did. She was obligated to invite Father and Tobias into the group, which she did. She was obligated to ensure that only Father and Tobias are in the Life 360 family, which she did. And she was obligated to create a password to prevent the child from disabling the location settings, which she did. What this child at the time was a 15-year-old child. You know, it's reasonable to consider that a 15-year-old child has some ability to take some actions, which may be contrary to what each parent is obligated to do with the court. Unfortunately, this child was not contracted or a party to the stipulation or court orders and has some free will. So there have been times that have been alleged that this child's phone was turned off, that the child was perhaps in the library or somewhere else, but those weren't doings by my client. There was no direct evidence which illustrated beyond a clear and convincing level
which is a higher burden than mere suspicion and even preponderance of the evidence, that she took direct actions willfully to violate those court
I want
orders.
to ask you about that term, direct actions. The operative language in the temporary order says the parties shall work together to ensure that the parties, and only the parties, always have unrestricted access to the child's location. So obviously the mother couldn't take actions that would interfere with the father having unrestricted access. What about omissions by the mother? Could an omission constitute contempt of the order that they work together to ensure unrestricted access?
It would, if an omission were contrary to that particular order, one could argue that that would be a violation of that court order. Yes, I would agree with that. If she did something in contrary to that order, I would agree, but the record doesn't reflect that she did anything or omitted to do anything that she should have done. The record reflects merely that there was a phone in the home. There was no evidence that the child used that phone. There's no records, phone records that the child used that phone. There's no records that my client took any action to disable the location settings. There's no indication that my client took any action to restrict or in any way act in any manner which she didn't provide unrestricted access to location.
Could not locking up that spare phone where the child couldn't get at it constitute an omission that basically facilitated the child in avoiding the father having access to the child's location?
I think that could be considered a stretch. I mean, she had a spare phone in case of necessity. The child who was 15 is resourceful. He's now in college. He could have utilized somebody else's phone. He could have utilized a computer.
She can't stop the child from using someone else's phone, but can she take reasonable steps to ensure that nothing she's doing is facilitating the child evading the 360 app
Parents
and the
can.
father's access?
If they're aware that those steps may hinder the violation, they can. But it certainly wasn't my client's intention, nor does any of the evidence suggest that she took any deliberate steps to do so. But it could, depending on the circumstances.
Can I focus on the transcript 193, RA 193 from the transcript? It's page 191, actually. Question, isn't it fair to say that 60 minutes after you dropped Tobias off in front of his father's driveway, you're getting a text message from Mr. Snow saying that Tobias is with him in his house? Answer, yes. And so the question is, does she have an obligation when she has that information to, under this rule, this order, the parties shall work together to ensure that the parties, and only the parties, have unrestricted access to the child's location, to convey to the father, here's where he is. He's at Chris Snow's house.
Well, the father did know where the child was at certain instances. So, that information was made available by the Department of Children and Family. So that information was
known. Does the mother have an obligation to tell him that? Is she in contempt is she violating the order if she doesn't tell him that?
The question is she in contempt? And if you look at the strict, plain language of that order, she is not in contempt because there's no direct order that she provide that information. The language itself, unfortunately or fortunately, is somewhat suggestive and altruistic of cooperation between the parties. It is not a direct command which says you have to do X, Y, and Z, like you have to pay support of $500 a week by 5 o'clock on Sunday. It is not an explicit direct command.
So maybe that failure to inform the father that the child's at Chris Snow's house wouldn't be contempt of the Life 360 provision. But what about the separation agreement saying the parties will alternate having the child on a weekly basis?
Well,
so that means that the parties need to make sure that the other party has the child, or at least take reasonable steps to ensure that the other party has the child.
It does, and I believe that my client...
Okay. So assuming that that's how we interpret it, why isn't the failure to tell Chris Snow, don't allow the child to stay with you, I need to make sure, or I need to take reasonable steps to ensure that the father has him, why isn't that contempt?
Well, the reasonable steps are that she drops the child off, which was uncontroverted every single time it was the parent with the father's time. She did so without incident.
Yeah, right. She does that, allowing all that.
She left the child. She took.
Right. But she knows he goes to Chris Snow's. Chris Snow informs her. and she doesn't say to Chris, stop doing this. He needs to be with his father.
Well, at some point,
Isn't that what the separation agreement at least implicitly requires?
well, if it implicitly requires that we're still left with the issue that there's no clear and unequivocal order, and the probate court is allowed to take measures to modify orders, enter additional orders, or enter other remedies that are sufficient to ensure a child's best interests. But the question before the court is whether or not there's a clear and unequivocal violation of a clear order. And the clear order, well, it's not a clear order, but the order is essentially that there's going to be a transition on Sundays. Doesn't say what time it's at, doesn't say who drops off the child, doesn't say who picks up the child. It just states that they alternate the time. That's all the order says.
So when she's dropping off, I'm trying to understand very concretely. She's dropping off somewhere in the driveway, and I think her testimony is, and this happened many weeks in a row, and I think her testimony is her practice was to drive away immediately so that the child could not get back in her car. Does she have some obligation under this order to do more than that, especially where she's learning at some point early on that he's actually going to Chris Snow's house, to do more? For example, make sure that the kid goes into dad's house before driving away.
That was certainly an argument made by father. And perhaps she has a moral obligation. Perhaps the court may consider that she has a parental obligation. That could be. But when you look through the lens of whether or not there's a violation of a clear and unequivocal order, she cannot be found in contempt, aside from the fact of whether or not she should have taken more steps. Arguments can be made that she should have taken more steps. This was, as the court noted, a difficult situation with a resistant child, and mother was left with not a lot of options. She dropped the kid off. She thought she was doing her best not to interfere. She left. The kid.
Wait, sorry. She's left with not a lot of options. I just gave you an option. One option at least. There's lots of options. That in fact, I don't agree that she didn't have a lot of options. That in fact, the option. What about the option I just gave you? A child, go. I want to see you walk through the door to your father's house.
Again, while she could have had a moral or obligation or practical obligation to do that, the question still remains as to whether or not there was a violation of a clear and unequivocal order. This had been an ongoing issue for several months in the probate court. There was no remedy to that issue. There were no further orders entered. The order wasn't modified. That was an order that was entered into about 5 years prior, I believe, when the child was younger, when no issues of resistance were affecting the two parties at the same time. Circumstances changed. You know, I think it's difficult when you're in that position as a parent to figure out what is best to do when you're, being viewed by your ex-spouse. You're under cameras, you're under scrutiny. I think it's a very stressful situation. So while there may be a moral obligation, maybe a practical obligation, but there was no court-imposed clear violation of that court's order. And that is why we're asking the court to vacate the judgment. The child was made available each and every week. It was during father's parenting time. Why doesn't father have the same obligation? He sees the child running away. Why doesn't the father go after the child? He also did nothing during his prescribed parenting time to take action. He left the burden on her and then seeks for her to enforce the child's compliance, which she cannot do. All she can do is comply with her own orders. I see that I have run out of time. If the court has any other questions, I'm happy to answer them. Thank you so much.
Seeing none, we thank you for your argument. We'll hear from Attorney Grilly. Hope I'm pronouncing that right.
You are, Your Honor. Thank you. May it please the court, Michael Grilly on behalf of the appellee, Aaron Smyth. Mother argues, first I want to address the issue of whether or not there's a clear and unequivocal court order here. As was raised by Your Honors during Mr. Xavier's presentation, that was not an issue that was raised at the time of trial. Therefore, we don't have the benefit of any analysis by the judge or findings by the judge. It should be noted that in this instance, the judge didn't enter findings, but specifically a rationale as opposed to specific findings. As to why this constituted a clear and unequivocal court order. Certainly the testimony that was garnered at trial was that mother at no time had any dispute or any conflict in her own mind as to what the order was or her obligations under that order. This was originally an order that was entered in 2019, and for a period of almost 3 years, they operated under an arrangement where the mother would be bringing the child to the father on Sundays pursuant to the court order. There was no testimony that she didn't understand what her obligation was, at least as bringing the child to the father's home on Sundays. There was never any dispute that there was an issue of time, that she was unaware as to what specific time. In fact, it's not disputed that she was in fact bringing the child to the father's home. It's really more of her actions subsequent to bringing the child to the father's home that call into question, and we believe led to the finding of contempt.
Is it her actions or her omissions?
Well, I was going to say, to some extent, both, given that early on, before father was aware that the child was going to Chris Snow's home, the mother was aware that the child was going to Chris Snow's home, and in fact wasn't sharing that information with the father. When the father would contact the mother, and indicate that the child is not here, mother's opinion, mother's attitude, her position was that that's not my problem. This is your time.
So that's an omission?
Well, I would say that not informing the child, or excuse me, not informing the father that the child was at Chris Snow's house, it's not necessarily an omission, it's a direct action.
How is it she failed to tell the father? How is that an action?
Well, because we would say that that is an example of her taking a direct action to hide the child from the father, as opposed to her taking an omission would be more in the mind of not contacting Mr. Snow and advising him to return the child, not having there to be some manner of punishment for the child for him running from the father's home to go to Mr. Snow's house. Further, the mother was aware of the court's interpretation of this order as being clear and unequivocal because she had already previously been found in contempt for this same sort of behavior.
Well, what action was she found, or omission for that matter, was she found in contempt for that she then repeated in the contempt action that's before us now?
Well, it was again the manner of the child going to Mr. Snow's home, not informing Mr. Smith as to what she knew of the child's location, not taking reasonable steps to ensure that the child was even in fact going into father's home. Her testimony was that she would leave the driveway almost immediately to prevent the child from going back into the car. That was deemed to be not credible by the court.
So just so we are all on the same page, I guess
Please.
literally, is this Record Appendix 46, the judgment of contempt on the complaint filed November 5, 2022?
Yes.
Is that where? Okay. So something that she was found in contempt for in this judgment, she then did again?
Correct.
And that specifically was?
The failure to abide by the parenting schedule so as not to either by action or omission ensuring that the father received his appropriate parenting time pursuant to the parties' separation agreement.
So the father, both parents were technologically savvy, I think.
Yes.
And they both worked in university tech, maybe.
In that vein.
In that space. I'm struggling to understand why the father couldn't, well, really both of them working together, couldn't do a better job tracking the child. And what I'm really getting at is, your opponent makes this point quickly, why doesn't the father do something more proactively to track his child's location and ensure his custody and his parenting time?
Well, I guess the question then comes, in my thought, what could he have done? The whole purpose of the Life 360 was to ensure that he'd have the ability to track the child. The evidence presented at trial, which the judge found credible, is that the child was going on occasion to the library at Mount Holyoke College where the mother was employed and leaving the phone there.
Right, but there's also, right, I get that, or I remember that. The child, I believe there was testimony that the child was going to school every day, 5 days a week during school, and during the weeks where the child was supposed to be with the father, but was in fact with Chris Snow, the child was taking his phone to school, and then it's not clear to me what was happening. What does the record support? Does the record clarify that in these weeks that the child was then taking the phone back to Mount Holyoke every day, 5 days a week?
I'm not sure, Your Honor, specifically if the record's clear as to that, what the child was doing on a daily basis. I know there were allegations raised at trial that the father was able to track the phone through Life 360 and found it to be at Mount Holyoke College, right. When clearly, then the presumption was that the child was not there.
Right, so I guess my question is, and maybe the simple answer is the father is not being the one being held in contempt here, and that may be the answer, but the father, if I've got these facts, if I'm remembering the facts correctly, the father is a fairly sophisticated technological person.
Yes.
If it's true that the child is taking the phone every day to school, the father could stand outside school and wait for the child to come out and make his way to Mount Holyoke College and say, son, come on, let's go home, and ensure his parenting time. And is that relevant to the finding of contempt against the mother?
Well, I think that's a fair argument, Your Honor, that perhaps he could have done more. But I think given, the totality of the circumstances and the emphasis that the court put on the credibility of the witnesses, the court found that the mother had engaged in a course of conduct to impede the parental relationship. And perhaps that would not have had an effect had he done that, because it was clear that for whatever reason, the child was not going with father. So I don't know that to take on this manner of self-help would have changed anything. We'd certainly argue it would not have changed the mother's behavior and what she did to impede the parent-child relationship.
I was just looking at the judgment of contempt on the 2022 complaint, and what the mother was found in contempt for there was a specific provision of a prior order governing the month of November 2021, requiring that the child meet with the father every Wednesday and every Saturday for dinner. Mother was found in contempt of that, but those provisions, number one, that provision lapsed as of December 2021, and number two, it's not even alleged here. The contempt alleged here is of two different provisions, so I'm not sure how that helps you after looking at it.
Well, I agree, Your Honor, that perhaps it doesn't assist, but I think the fact that historically the court had found the mother in contempt for parenting orders is certainly helpful to the court in gauging her credibility and determining whether or not she had indeed taken either actions or omissions in violation of this court order.
So you mentioned the mother's credibility. The judge didn't credit the mother's testimony on a number of issues. Number one, that the child didn't visit her at Mount Holyoke. She didn't credit that the mother told the child not to turn the phone off. She didn't credit that the child doesn't use the spare phone on the mother's plan. But not crediting testimony doesn't create evidence of the converse. Would you agree with that?
I would agree with that, Your Honor.
So what is the evidence that the mother did do those things? The judge may have disbelieved her denial that she didn't, but where's the affirmative and necessarily clear and convincing evidence that she did do those things?
Well, I would agree, Your Honor. In this instance, I don't think we can point to any specific smoking gun that shows that the mother did these things. I think the judge, given that there was an accusation, given that there was a denial, I think the judge is within her discretion to gauge the credibility and to some extent breaking the tie and making a determination as to whether or not the mother's denial is credible.
Well, if this were a preponderance standard, then maybe the phrase breaking the tie would have a little more weight. But where this is a clear and convincing evidence standard, I'm having trouble seeing how disbelieving the mother establishes that the mother actually did the things she said she didn't.
Understood, Your Honor. Understood. And I think that certainly is an issue as it relates to the standard that the judge is seeking to apply here.
Is there any obstacle to the agreement, I guess the settlement agreement as incorporated in the judgment and or the temporary order to clarifying those so that they more specifically govern what the mother can and can't do?
Well, certainly either party, if the child's not going with the father, whether it be by the child's own will or through some action of the mother, either party could have sought to modify that order. If the mother felt that there needed to be some sort of clarification as to her obligations as it relates to the transportation of the child during this period of time, whether she be required to see that the child goes into the home or take any specific action.
She could have sought that clarification.
She could have certainly sought to modify it.
So could the father.
Absolutely.
There was a trial on a modification complaint scheduled, I think I saw, for maybe the fall of '24?
Yes.
And, I mean, has anything that's happened in this case since this judgment of contempt affected the mother's obligations on the issues that we're talking about?
Well, no, I will indicate, Your Honor, that modification action did not go to trial. In fact, there was a stipulation that gave father sole physical and legal custody of the child with a provision that the mother not have any contact with the child of any nature, not just parenting time, but phone contact, email, anything for a period of at least 90 days. And again, this was by stipulation.
Okay. All right. So no modification of the obligations that are at issue here.
Correct, because at that point, that issue was moot because there wasn't parenting time as between the parents. Father had sole physical and legal custody of the child.
And just to reassure Mother's Counsel, I mean, this post-judgment, post-contempt judgment event would not influence our decision on whether the mother was in fact.
And there have been other changes that counsel's well aware of that affected even that, but aren't necessarily relevant to the issue that we're dealing with here today. So as my time is running short, and unless Your Honors have any further question,
Seeing none, we thank you all for your arguments, and that concludes our session for today. I'd like to thank our court officers, our law clerk keeping time, and our other law clerks and the entire court staff for their assistance. And with that, we are adjourned.
Thank you.